Considering a lunch month. The matter arises in the National Investigating Agency Act. Accused returned approval. Not 439, the line of judgment say 439 has no application so far approval is concerned. I moved a matter before the learned single judge on Monday. The learned single judge not basing on 2014 Supreme Court judgment, wherein it was on different, it's only there it was only an accused. But the learned single judge not felt it should go before the bench only. It was numbered it before lordships. I would have not insisted my lords to take away the lunch motion, but on Monday, the petitioner's mother passed away. He wanted, he wanted to offer prayers to her, so he's requesting a lunch motion subject to my lord's convenience. I'm very grateful. I'll go to my lords.
With your kind permission, Your Lordship, Family Court Appeal of 2023, Your Lordship. A fresh IA has been filed with regard to custody of Diwali for Diwali celebration. A fresh IA is filed with regards to custody for Diwali celebration, Your Lordship. When the matter came up last time, it was posted to 1611, Your Lordship. The IA will become infructuous, Your Lordship, if it's posted on that day. Request for it to be heard 12th, Your Lordship. 9th, Your Lordship.
May make a mention.
Tomorrow, Your Lordship.
May make a mention, Your Lordship.
Consider, Your Lordship. 6, Your Lordship. 6 years.
So you have granted even
Yes, Your Lordship, but the same were reduced by this honorable court to 2 days a week, Your Lordship. The same were reduced by this honorable court to 2 days a week. Yes, Your Lordship. Your Lordship, only seeking because it's the first time that Diwali is being celebrated with the boy, Your Lordship. Humble request.
Family court interacted with the boy also. Maybe tomorrow we'll see.
May make a mention also. The criminal appeal pertaining to the year 2018, my lords. The appellant is in jail since 5 years, 8 months, my lords. The
20th,
obliged.
Monday.
Obliged.
Yes. Items?
57 and 58. Kindly have it after 2 weeks.
One second. You are representing Mr. Mallikarjun.
Respondent, madam.
Mr. Satish, did you inform other side?
I'll inform you.
Don't say I will. First you have to inform, then come back.
But item number 8, my lord. Item number 8,
Wait.
seeking 2 weeks time.
Wait for 5 minutes, 8 minutes. Yes. Any other mention?
We are in 772
It is there in the list or out of list? What do you want?
It's been pending since 29.
Criminal appeal. What do you want?
It has not come. It has only been for hearing 2 times, and since then it has not been listed.
What is the urgency now? 2014 appeals we are hearing of.
Committed suicide from all these cases. He committed suicide.
Petitioner. So even then he filed. What is the matter about?
The check bounce, Mr. Lordship. The case was dismissed.
Writ petition or criminal appeal?
Appeal, Your Lordship.
Criminal appeal. Offence is enacted. It is before us. It is before a division bench. Very good. Check in the internet and come back. Where the appeals where the punishment is 10 years and above 10 years are before us. Not enact matters. Check and come. Please wait for 8 minutes.
And my
No,
item
we
is
want
6
Go, if you
number
want to go, please.
35.
If you want to leave, leave.
I'm
We'll
sorry.
Go through the document.
I'm sorry, my lord. It
Any
is
item you can't make a mention, Mr. Durga.
35.
Ask one of your colleagues to be here. We said we will go through the document.
I'll wait.
Sir, we will wait. 1 second. Babu, online appeal. No?
This is a family court appeal.
Who filed OPS?
In this case, why filed the application for
Restitution. June order, September order. Anyway, we'll order notice.
In this case, before completion of the 2 months period, she came to the house and made a
We
galaga.
are not dismissing your appeal. We are allowing, admitting your appeal. We are ordering notice. Please serve notice, we'll see. Admit,
I am seeking stay.
not today. She has not filed any execution application.
Came to the house, Mira. We were given 100 complaint and she went away. I filed appeal FCA 196/23. Husband filed the application.
What is the problem?
Problem is She is.
Why you are opposing section 9 application?
Section 9 application is allowed and my application was dismissed.
What is your application?
My application is diverse.
Where is that OP?
OP, FCA 196/23.
FCA
FCA 196/23. And it is posted to 6/2/24.
6 to 24.
Both appeals are filed at a time, but it is numbered later.
But she is creating the problem. Now, normally in section 9 applications, we are not granting states. What?
నేను కూడా అడగలేదు. ఏంటంటే ఇంటి మీదకి వచ్చి కూడా ఇది మళ్ళీ ఇంకో police
One
case
second,
అయితే
wait to mention all those facts in our affidavit. This order is dated 26/9/2020.
Yes, ma'am.
చెప్పలే కదా. ఆ, 100 para 5 లో ఉంది. We will grant stay for 15-20 days.
Yes.
ఇది అప్పీల్ వచ్చేసి అడ్మిట్. Is a government support. On what ground you have filed diverse application?
Reality and.
It is the same. Huh?
Legal affairs. Legal affairs and.
Lord, sir, this is a case where not there is allegation of illegal detention. Lord, 41-year notice was served and he was sent away. Lord, we are filing counter today, my lord. But there is overnight stay of the alleged detainee was in the station from previous night to the next day afternoon, my lord. The higher authorities are also taking action against the higher authorities are taking action against the concerned officer, my lord.
So we'll grant you 2 weeks time,
My lord,
right?
I will report to your lordship.
Mr. Veerababu.
Much of Millet.
So according to learned government pleader, higher officials are looking into the matter. We are adjourning by 2 weeks.
Oh, bless me. You're blessed. They'll impose punishment once it is proved.
Learned.
Much of Millet.
My lordship, I'm appearing by of Vadlakund Ravi, my lordship. For petitioner, my lordship. The senior is in out of station, my lordship, seeking time for 1 week, my lordship.
So this is 7th, 1 second. This is 7th adjournment.
Yes.
We are not inclined to adjourn this matter. Tell your senior, we are listing it on 14th. Either he has to argue or we will decide the matter on merits. Habeas corpus. This is not the way. And at request of, I know, we know the facts. We will decide the writs. At request of learned counsel for petitioner, list on 14th. However, it is made clear that no further time will be granted. Further time. We will decide this application on 14th.
But this is a case where my lords interacted with all concerned, my lord.
My lord, I maybe had.
Why it was adjourned? For hearing of the.
My lord,
Yes, please.
this habeas corpus is petition is filed by 2 minors, aged 9 and 10, my lord, for illegal detention of their mother by the respondent number 4 and 5. My humble submission, my lord. In the case where the minor's interest is involved, my lord, the Child Rights Act comes into effect, my lord.
This is writ of, 1 second.
Yes, my lord. Yes, my lord. I'm going, my lord. I'm going.
Please let us, you are not permitting us to say something. We are seeking clarification from you. Yes, we are not coming in your way.
Yes,
We will hear you up to 1:30. We don't have any problem,
Mela.
right?
Mela.
Please permit us to say something.
Mela.
This is writ of habeas corpus.
Yes, ma'am.
Please confine your submissions to this particular.
Yes, my lord, that is, ma'am.
Don't
My lord,
convert this writ petition into property.
my lord, the person who is under alleged illegal detention is a mental retarded person on record, my lord. Mental detention. The act of mental disability come into force in
Mental retarded person, 1 second. Mental retarded person gave birth to 3 children.
My lord,
Petitioner, fifth respondent.
it is on record, they submitted the medical record before this another.
Correct, correct. We have also interacted with.
Yes, my lord, yes. My lord, the marriage of the woman was performed in the year 2010, my lord.
First marriage or second marriage?
Second marriage, second marriage,
2010.
from whom the petitioners were born. Since 2010 to 2022, my lord, the respondent number 4 and 5 did not permitted that woman to visit their house, my lord, because he used to create nuisance in the house, my lord, because of her mental retardedness. My lord, during the 13 years, my lord, the child came before your lordship and your lordship has interacted with them. Even, my lord, the children were not permitted to visit the house of the respondent number 4 and 5 during last 12 years, my lord, after their birth. They don't know that their uncle and half sister who are respondent number 4 and 5. Because the respondent number 4 and 5 feels that if a mental retarded woman resides in their house, their children's marriage, who are female, my lord, at stake. They will, somebody comes and sees that a woman, a mentally retarded woman is residing in the house and they can't. That is the fear they got. During last 12 years, they never allowed me. My lord, the fate of these children turned into title, my lord, in the year 2022. When their mother, the property gifted to her by her mother and paternal uncle, she has expressed her willingness to gift the property in the interest of minors.
Already gifted.
They gifted the property in the year 2022, which I filed.
Sale deed is there at page 14.
Yes, madam. I filed. Lord, under the Child Rights Act, my lord, where the interest of the children is involved, my lord, they have a say. Their protection, my lord, they have a say in respect of their financial interests. Lord, the act is promulgated on the aegis of the United Nations, my lord. All the governments, my lord, because of these complications in the courts of law, my lord, that is, the United Nations has forced all the governments to sign the treaty.
Force, they never force.
The
Governments are signing.
my lord, the children's
United
right
Nations
is,
never force any government
my lord,
to sign a particular law.
my lord. In respect of the disabled persons also, the law comes from the United Nations, my lord, in respect of all countries. My humble submission, my lord, in this case, the woman is a medically recorded, my lord, person suffering from mental illness. All these years,
Sorry for the interruption. One more question. His name is Kaja Shamsuddin, husband's name,
yes, ma'am.
right? He is residing at Shambunipet, Rangasahipet, Warangal district.
Yes, ma'am.
Whether it is his own house or a rented house.
It is his own.
He is there in the court? He is not
No, he's not.
own house.
Yeah.
It is his own house.
Yes. My lord, the future maintenance of the children was met with the income meted out from the property gifted by their mother, my lord. Since, even though prior to gift also, they used to survive on the income from the property gifted by their mother. When their mother has gifted the property, my lord, to them in the year 2022, the respond number 4, particularly, my lord, I'm saying he's a recorded land grabber in Hanamkonda, my lord. I'm saying on record.
Mr.
See.
Salim, Mr. Salim, one second. Take your seat. Mr. Salim, don't convert this writ of habeas corpus into property dispute. We have cautioned you in the beginning.
My lord, my humble submission, my lord,
If
my
you
humble
still pursue,
my humble submission.
you are,
My lord, in
arguing
the
at the
case
cost of,
of, my lord,
second.
previously,
one second, you are arguing at the cost of your friends.
my lord,
Of course, we have to be here up to
My lord.
2:30 and 2:30 to 4:30. We will hear this writ petition alone and we will raise and go. We are not going to lose any.
I'm not saying, my lord, because the interest and survival of the minor two girls in
Interest and
my lord,
survival.
I have to take the pain.
Interest and survival, you are asking us to decide in a writ of habeas corpus.
My lord,
Is it the way?
that's why I'm saying, my lord.
Please concentrate whether there is any illegal detention of alleged detainee by respondent 4 and 5. Please concentrate on that.
Yes, my lord.
We
Yes,
will not go beyond that.
yes, my lord. My lord, in the recent trend, my lord, I am on record in this humble court in habeas corpus. Not wherein previously habeas corpus was interpreted within the scope of Article 226, my lord.
Correct, even now also.
But now that is not there.
Saying
my lord.
no.
Now that is not there.
We are
Wherein
discussing from 5, 6.
The mother is in my case, my lord, the mother is not permitted to see her children in a habeas corpus. The courts are taking pain, my lord.
Hmm.
The scope of the habeas corpus, your lordship knows. Lord, in this case, by taking her forcefully, my lord, a complaint is filed at page number 24, my lord, against the entire family of these petitioners, my lord. The offense is made out for gifting the property in the name of.
Only against husband, Mr. Salim. Only against Shamsuddin. Raja Hamsuddin. This is not against all the family members, 498A.
No, my lord.
See the complaint.
All the family members. All the family members, my lord.
Only husband is
498 is just a part for registering the document by the mother in the favor of the children. A 420 case is booked, 471 case is booked, and everything is booked to coerce them for submission, my lord, for surrender of that. My lord, I have to say, my lord, I have to say, before the death of the grandmother of the children, my lord, she,
paternal grandmother.
yes, my lord, who gifted the property,
Maternal.
maternal. She brought the document to the petitioner's house, my lord, and handed over them by warning them her son is, obviously he will take away the property. Take away the property in future. What is no correct. My lord, it is adjacent to his house, my lord. My lord, as on today, he acquired the house, my lord. By registering the case against them, he acquired the house.
1 second, 1 second. We will go with you, right? Then please come to page 14 of your metal papers, read papers. Mother of the petitioners, that is alleged detainee.
Yes,
She has already executed gift deed in favor of the petitioners. Is it
Yes.
not?
yes, ma'am.
If they occupy illegally, respondent 4 and his brother, what is that they have to do?
My lord, I had to further remedies, my lord, but my lord,
So many remedies.
my lord,
To protect your
Article 21 of the Constitution in conjugation with Article 226, my lord. In these type of cases, my lord, this court as well as the advocate has to take pain, my lord. This is happening in the country, even the Supreme Court.
Take pain. Who is coming in your way?
My lord,
I am not
Now-
you are not coming in your way. Ramon is not coming. Mujib is also.
my lord, my humble submission, my lord.
Protect your
My
property.
lord, apart from these pleadings, my lord, I am saying, your lordship has interacted them in the court of law.
Correct. With all the.
My lord, when the mother went away, both the small kids went to her and just a word uttered again, on hearing, my lord, Mommy, please come with us. That is the word they uttered. She is asking respondent number 4 and 5 and their mother, my children is calling whether I have to go now. I'm bringing to the notice of this honorable court, my lord, the true picture of this case.
We know,
My
Mr.
lord, my lord, if the woman is permitted, my lord, during last 3-4 months, she is staying with the respondents, and I'm told that she was threatened that she has to depose like this, before the court. Otherwise, she will be sent to, my lord, to prison. But my humble submission, if the mother is permitted to reside with the children for 2 days, my lord, 2 days now, if this court interacts her after that, my lord, if she want to reside with those persons, my lord, I'll, on behalf of my client, I am assuring, my lord, she will withdraw the habeas corpus has to be closed. This is the case, my lord, wherein the courts, as well as anybody, is not having any power to, my lord, to disturb the interest of the minor children, my lord. And their interest is involved in this case. I am requesting this honorable court, my lord, at least to take pain, my lord, by permitting the mother at least to stay with the daughters, my lord, for 2 days, with whom she resided all the 12 years, my lord. After that, if she deserves to, it is the statement recorded by this court is under coercion, my lord. She is not, my lord, mentally she is ill, my lord, on record. I'm humbly praying this honorable court either to allow the writ petition, my lord, by directing them. Otherwise, my lord, the mother
Directing them?
by joining the parents, mother and children, my lord. Otherwise, my lord, kindly dismiss by writ petition by allowing the mother to stay for 2 days, my lord, with the petitioner. Then she says that she want to reside separately, my lord. I'll certainly withdraw my petition. Ample submission, my lord.
First in the count of I filed, my lord. First instance, my lord, they given conjugal rights notice, my lord. After that, my lord, they filed this writ petition, my lord. The counter I filed on 21/7/2023.
Where is the notice issued by them?
With the counter I filed.
Legal notice, huh?
Yes.
Page 6.
Subject that
Page
material, they filed this writ. 21/7/2023. They issued notice, my lord, including court and respondent, including HHO. And the second sentence, my lord, para 7 of there after one hand they said that
What is your understanding of the case, Mr. Raman? Forget about
it's only family dispute, only for the property, my lord, they are
otherwise,
Otherwise,
no writ of habeas corpus, no 21/7/22 notice, nothing. Next.
My connection is, my lord, only that effect, my lord, and only judgment, my lord,
Any judgment, yes.
not maintainable.
How many judgments you are citing?
2 judgments, my lord. One is, my lord, the Muhammad some Hussain versus State of UP and, my lord, another Vidya Varma versus Shiva Varma. These 2 petitions, my lord, para 7 of, my lord, Vidya Varma, my lord,
Para 7, huh?
yes, sir.
Didi? Mohammed Ikram said,
This principle applied to Article 19, 1F and 31 by the bench of 5 judges of Malad, joint to Malad, who held that violation of rights of property by a private individual is not within the purview of these articles. And Malad, the habeas corpus
is it Mohammed Ikram said?
Malad, in that Malad,
Para 13.
para 13.
What is the principle laid down?
Yes, so then down Malad, the para 13 Malad. The writ at the instance of a husband is very rare in English law, and in India, the writ of habeas corpus is probably never used by the husband to regain his wife, and an alternative remedy under section 100 of the Penal Code, Procedure Code is always used. Then there is a remedy of a civil suit for restitution of conjugal right. Husband takes recourse to the debtor when the detention does not amount to an appeal and the other moment. So, as of now, madam, there is no illegal detention, madam. He is registered with the Malad in her house with the daughter Malad and his brother. There is no illegal detention. Even if there is there is the notice Malad issued by the
And you are not going to take that property under any circumstances.
property Malad. I am not.
Anyway, already it was executed.
If I take Malad, they have a sort of Malad. And we given that Malad is able to do.
Minister? So she lodged a complaint against petitioner so father. It's illegal picture actually. It would have illegal talking cancel this day. That's all, Mr.
Yes.
Did you go through page 24 complaint written by fifth respondent?
That is given by the Malad.
Fifth respondent.
Yes.
Second, daughter.
498 Malad. Any one of Malad.
498. Read page 24 complaint. 24 of read papers.
Yes.
Complaint given by daughter with
Daughter.
first husband. Read it. You will come to know everything. Mujib, you also please read page 24.
22 minutes.
24 of the read papers.
No
Published. Maternal uncles, wife, daughter with first husband and one son. Two daughters, father, second husband, one son. This particular property. లెటర్ చదవాలి మాకు వినిపించదు మరి
నా తండ్రి యొక్క మెంటల్ స్టేటస్
Hmm.
తీసుకొని పైన వివరించిన వారందరూ కలిసి నా యొక్క తల్లి యొక్క నా యొక్క అమ్మమ్మ అయినా నా యొక్క మామయ్య గిఫ్ట్ గా ఇచ్చిన ఇల్లు నెంబర్ 3/492/1 130 చదరపుగా ఉన్న నా యొక్క తల్లి పేరుగా ఉన్న ఇంటిని రెండవ భర్త అయిన తాజా సంతోషించి తన పేరు మీద ఇల్లీగల్ కార్డ్ మరియు నా తల్లి యొక్క ఆరోగ్యం తల్లి పరిస్థితుల్లో ఆమెను రిజిస్ట్రేషన్ ఆఫీస్ తీసుకెళ్లి మభ్య పెట్టి చీటింగ్ చేసి ఇల్లును తన పేరు మీద 30/12/2021 డాక్యుమెంట్ నెంబర్ ద్వారా మార్చుకోవడం జరిగింది. ఆ తల్లి వారు పోషించడం జరిగింది. మేము మా మామగారైన మిగతా పర్టికులర్ వేరు గారి ఇంటి వద్దగా ఉంటున్నాం. మేము వెళ్ళి వారి ఇల్లు మాటి ఏం చేసుకుంటారో అని చేసుకోండి బెదిరిస్తున్నాం. ఇల్లీగల్ డాక్యుమెంట్ క్యాన్సల్ చేసి నా తల్లి పేరు మీద తిరిగి రిజిస్ట్రేషన్
So maternal uncles and this daughter with first husband one side, two daughters and second husband is other side.
Yes.
In between property and Mr. Mujib Kumar's client.
My lord.
Entire case.
But they cannot change by
What is it?
My lord, the remedy of the unofficial response is to file a suit for cancellation. Unofficial response. my lord.
Fifth respondent.
Yes, to file a suit
That
for
is one.
cancellation of
With regard to this 24.
this.
Say on the detention, habeas corpus.
My lord, detention, my lord, I would not say anything because my lords have interacted with all concerned, my lord. And my lord, at one breath they say that she is mentally unsound, at the other breath they say that she went to the register office and executed a will. I mean, executed a gift deed. That is running contradictory to their own versions, my lords. So, my lords, as far as detention is concerned, I will not be able to speak anything because my lords, my lordships have interacted with all concerned. But my lord, this page 24 complaint, crime has been registered.
Even on 24 also.
Yes, my lord. Yes, my lord. I see from my lord.
Page number?
Same page, my lord. Page 24. One minute, one. My lord,
60, crime number
368. Yes, at the bottom, my lord, left hand side, bottom. Hands, manuscript.
Can you read sir under 498, Mr. Mujib?
No, as far as the upper contents of the first two paragraphs regarding harassment and other things are concerned.
Harassment can second daughter with first husband.
Yes,
This is the complaint lodged by fifth respondent.
yes, first
Daughter
daughter.
with the first husband.
Yes,
Can you read under 498?
my lord, that is what they have done, my lord. And 420 also, 420 also is,
420 is what? What is the stage of the investigation?
that I have to ascertain.
Three
Millards.
sixty-eight.
I have to ascertain minutes that I don't have
But
immediate,
according to, there is no illegal detention.
no illegal detention.
Disputes are with regard to property.
My lord, once she is capable of executing a gift deed, my lord, she is capable of deciding with whom she can reside.
And she blessed with 3 children.
Yes, 3 children, as your lordships have at the inception, my lord, observed. That she has begotten 3 children through the second husband, my lord. And lords, we are all out of the court, my lord, because your lordships has already interacted.
My lord, my humble submission.
I will ascertain and inform about the stage of that case.
By 130.
Yes, my lord.
My lord, as per the acts, my lord, law, my lord, the mentally retarded person during the period of during the interregnum of 2 mental conditions, my lord,
Lunar interval.
executes a document, my lord, is a valid one. My lord, the other side has to prove that at the time of execution of the
We are
document,
not concerned with all those things.
my lord, yeah,
We are not deciding whether
my lord,
gifted deed is valid
my lord.
or invalid. We are not
When he
deciding.
asked.
This is written.
On the other hand, my lord, the notice is sent to the father, my lord. The notice is sent to the father, whereas the petitioners are petitioner in the present habeas corpus is minor children.
Minor or children represented by again their father.
My lord, it is the legal.
We will do one thing.
My lord.
Sister suggested. We will send both the minor daughters to the alleged detainee, whether they are prepared, leaving her father
My lord.
to this particular. In
Subject,
fact, it is their house.
subject to condition, my lord. Subject to condition.
Condition
See,
is
respect number 4 and 5. My lord, there is a threat for their life, my lord, at present. My lord, kindly again call them.
protection.
Yes.
5
No
acre
protection
parcels
or
with
in
SI,
family
2
matters.
SI.
My lord,
We will
everybody,
provide protection.
including.
One second, answer. We will direct superintendent of police this particular district
Right.
to provide police protection to both the minor daughters
Right.
with 5 AK-47s, 2 SIs, 10
Right. That
24
that is
24/7
that is not
with
very-
even women constable.
that is not
1 second. Are they, whether they are interested in joining the mother, get instructions, report us by 1:30. We will provide you necessary protection. We will ask the SP to provide a beat there.
Yes, my lord.
He is ready,
Yes.
my lord.
free of cost.
My query, my query.
Very late in the house, discuss with your clients and come back at 1:30.
No, my lord, not myself, I'll say, my lord.
And then?
My submission, my lord. Whether the respondents 4 and 5 will be present in the same.
They will not.
I'm assuming, my lord. No.
Children and mother,
My lord.
only 3 people,
Yes, my lord.
1 month.
Lord,
Let them
with-
stay together, come back.
Without asking my clients, my lord, I'm saying yes before this honorable court, my lord, that they will meet their mother.
Heard. Sri M. Salim, Land Council for Petition.
One point, Resama.
Mr. Mujib, tell us the stage of investigation.
Yes, my lord, 1:30 by 1:30.
Yes, Mr. Poche.
This may be closed, Miller. They have filed a counter, Miller. That petition is involved
So-
in a crime.
Prime number.
Crime
Prime number?
number, Miller.
Next one.
379. What about your bail, Mr. Poche?
152 by 2023, Miller.
Bail.
Images, sir.
It's granted bail.
Sri D. Poche, Land Council for Petition.
My lord, sir, we are filing a counter today in the registry, my lord.
PD Act.
PD Act, my lord,
What is the case, sir?
five cases of bike thefts, my lord. The bikes are being stolen from, my lord, from,
We will list it on 16th.
yes.
We are filing counter today. Collect counter. If you want to file any reply, please file.
Stage.
3 years only.
3 years కాదు కదా ఏం చూడాలి మేము PD Act లో. How many judgments you have?
There is no public regard.
We'll consider that. You want to argue today itself? Counter is not there. We will list it on 16th. The request of learned special government leader to file counter 16th. Yes.
My lords, in this case, they have served, they have filed a petition, my lord, affidavit, my lord. This is a case where, my lord, the allegation of threat by the police officers, my lord, they filed affidavits.
We have directed you to file counter along with CCTV footage from 1/10 to 2023 to 6/10. The other day, Mr. Malaysian said CCTV.
My lord, sir, from 26th of September to 14th of October, my lord, the CCTVs were under repair. And we have filed, we have mentioned in the counter also, my
Filed
lord.
already?
Yes, counter already filed, my lord.
Where is the, 1 second. You have filed reply? Counter on the reply?
Ithana?
Reply is not there.
My lord's page 6, my lord, para 15.
Reply ఉంది అదేంటి మీరు reply is not there. Give the yes or number. ఇది list on 16th. In the meanwhile, registry is directed to verify and put up form reply filed by petitioner to the counter filed by
Counter filed by fourth respondent.
4th respondent. 16th.
But I'll also file.
Why?
There are two ideas.
One IA is
There are two ideas.
One IA?
One is for appointment, including of nodal officer, because they are filed counter stating that CCTV cameras of concerned office are not working on certain 26/9/2023 to 12.
1 second. Who is the nodal officer according to you? Huh?
Filed counter.
So you want to appoint a nodal officer?
It's told me implement the nodal officer
We will decide on 16th. Yes.
Monday morning.
Monday is a holiday, Mr.
Much obliged.
So respondent spoke to 8. The approacher for filing of counter informed the other side. He's taking time, my lord, she is a different person. Counter is taking little time, 2 weeks time.
Cheppara.
1 second, Mr. Mujib.
My lords.
On 10/10/2023, we have directed you to get instructions with regard to action taken on the complaint dated 6/7/2023. What are your instructions? Therefore, we said we will go through the docket. What are your instructions? Last time you have submitted written instructions, but they are silent with regard to action taken on 6/7 complaint. Is it not? Do you have copy of written instructions?
Yes, my lord, I have.
Basing on the above complaint, GD entry. Which complaint? 6/7 complaint. Huh?
Yes, my lord, 6/7.
You have made GD entry.
Yes, my lord.
What is that you are?
And inquired with the, my lord, at the first page bottom there itself, my lord. And inquired the petitioner's wife and alleged persons Riyaz Mithilesh Singh, Mahesh and Chandapriya on 20th July 2023. The petitioner's wife informed that the petitioner comes home in a drunken condition every day and harasses her physically and mentally, and also her minor son.
Wife.
Yes.
He is harassing wife.
Yes. Due to the unbearable harassment, since 2 years she is staying separately with her son. Even though she is staying separately, petitioner continued to visit her, asking to stay with him, and she is not interested to stay with him. Stay separately. Since he is regularly visiting her house and causing annoyance to her and also disturbing peace and harmony, she joined her son Shasad in
residential school.
Yes, my lord. Run by government, and her son is now studying 9th class. The petitioner's wife filed divorce case against the petitioner before the
In 2021 itself.
Yes, my lord.
No, it is pending.
Yes, my lord. The inquiry further revealed that Riyaz, Mithilesh, Mahesh are also deaf and dumb. Therefore, the allegation made by the petitioner that the said persons have abused him and threatened him is absolutely false and denied.
Hmm.
This is the situation.
Both are deaf and dumb.
Yes, my lord, all of them.
Petitioner's wife is residing in Sainpuri secondary.
Whereas the said three persons are not residents of Chandrapriya did not abuse or threaten the petitioner. Chandrapriya's parents are also deaf and dumb. But almost everybody is in that condition. My lord. So therefore, the allegations against them is unfounded. My lord.
Accepting 8 petitions.
So the deaf and dumb people used to take her services as a translator whenever they require her services. It is submitted as per inquiry. No cognizable offence has taken place as alleged by the petitioner since it is a family
This
dispute.
family dispute. 10-22 Isaiah Police, Chikadapalli, Hyderabad.
My lord, and the next sheet is the
Guardian of the school.
yes. Next sheet is the inquiry report. It is
Chikadapalli Police.
closed. My lord. Petition is closed. Last sheet, last page, bottom.
As the both, read, 14th column.
Yes, 12th column. My lord. Recommendations of inquiry officer and further course of both parties were set together and counseled in the police station, and they agreed not to disturb each other. They will follow the court directions which is pending in the family court. Hence, the petition is closed. And decisions, that is column 14, as the both parties counseled at PS and they agreed to settle the dispute in the family court. That is, will not abide by the order of the family court. Hence, the petition is closed on 23/7/2023. My lord.
What to do? All are deaf and dumb.
My lord, after the sent notice to the SHO and the Commissioner of Police, they closed the petition. Till date, there is no action. After 1 month only, they closed the lab.
You have
Petitioner also have an interpreter and he has also some evidences. Petitioner minor son have to the petitioner and crying, my lord. They are all residing in one roof, my lord, the unofficial respondents, and not sent to the school, my lord. They are giving ganja to the petitioner minor son. That's what our allegations, my lord.
Who is giving ganja?
Minor son, they are
Ganja.
Mithilesh Singh.
Huh?
Mithilesh Singh, respondent number.
Mithilesh is. Who is Mithilesh?
Respondent number
Huh?
5, my lord. Respondent number.
Who is he?
They have some association, my lord.
What is the association? Tell us.
Defend
He is instructor. You want to translator?
no, my lord. They have partially defend Mithilesh Singh. Chandrapriya is a translator. Respondent number 8.
It is translator. What is your apprehension today? Where is the boy now? Where is the boy? Where is the boy, Mr. Mujib?
My lord, sir.
According to him. He is in hostel,
Yes, my lord, in the residential school. Yes.
residential school. Kada. Where is the question of
That is at page 2 of the instructions.
correct?
My lord, unofficial respondent number 4 not sent to the school. That's what we filed.
My lord, as
case.
per our instructions, because the child is being disturbed only, he was kept in residential school.
What exactly is your grievance, Naresh?
We will produce some videos, my lord, on exit regarding child.
What videos? What for?
He don't want to stay with her mother, my lord. He calling to the
He don't want to stay with the mother. Where is he now? At present, where is he?
custody of
Master. What is your problem? Tell us.
వాళ్ళ మదర్ ఇంట్లో ఉన్నప్పుడు మేము ఈ కేసు ఫైల్ చేస్తున్నాం మేడం. ఇప్పుడు అతను ఎక్కడ కూడా మాకు తెలియదు.
ఇప్పుడు ఏమైనా ప్రాబ్లం ఉందా? Any problem? Boy is studying in a hostel, residential school. If you have any problem, tell us. We will try to resolve.
No problem. If stay with her, that's what problem.
There is no question of providing drugs to him.
Yes.
That much we will assure.
If stay with her, that's only problem. Not otherwise. Obliged.
We'll close it. We will grant you liberty. If further, if there is any grievance, you can come to this court or avail other remedies.
Well,
We will
anyhow,
grant you liberty.
anyhow, case is pending in the family.
Anyhow, case is pending. We'll grant you liberty.
Kindly may take instructions, my lord. I will
The
not
instructions
stand
will be
and proceed.
pending. This we will record, right? Now close.
filed as alleging that there is illegal detention. The two affidavits were served to us, my lord, one by the,
1 second. He said he will file a.
yes, served, my lord. We have received two affidavits, my lord, one by the petition, the other by the council, my lord.
R6 is impleted already.
Yes, my lord, I'll have to file objections to these affidavits, my lord.
Which affidavit? What about counter of 6 respondent number 6?
Counter is filed, my lord.
Counter
Now
is
they
filed to
they
6.
come up with, yes, my lord. Now they come up with two affidavits stating that, my lord, police are threatening them to withdraw the writ petition.
No, respondent number 4 file counter.
Six
Six
also.
also.
Because, my lord, task force
We
people
are
have
aware, Mr. Mujib, 1 second.
counters are already.
First, we are going through the counter filed by Mr. Srinivasan, affidavit filed by Mr. Srinivasan.
Yes. Advocates affidavit, my lord.
Paragraph number 3, is it not?
Yes, my lord. Paragraph 3, my lord. They say that some
15,
friend of the circle inspector met them.
Mobile number is also mentioned.
But that is
14th October 2023, mobile number is mentioned, time mentioned.
that is the friend's mobile number, alleged friend of inspector, not the inspector directly. But
What was the counter?
yes, my lord.
To these affidavits. At request of land. Special.
Because some, but there were calls from the advocate to the
21st.
published.
Mhm. How many ground cases are there?
Solitary cases taken as.
Solitary.
Solitary case of NDPS will also.
NDPS.
Yes.
So 120 kgs of dry ganja.
What about history? Ma'am?
History, there are, history, 3 cases have been taken.
Ground case is 180 of 2020. Ground case.
76 of 20.
My lord, sir, this can be disposed of, not allowed, there is no objection. This can be allowed, my lord.
So where is 76? Ma'am?
Because such similar type of writ petitions you are
One
not.
second, we are
Page number 29.
page number
29 of my.
counter they have not mentioned. 76 of 2023. That is serial number 3, page number 11. 20B of the NDPS Act. What is the quantity seized? 120 cases of ganja.
120 kgs of dry ganja.
That was recovered from the petitioner. What is the allegation?
He's the owner of the car.
The owner of the car. He is A1 or A2? What about A2? You don't know. Where is the copy of FIR in 76? What about charge sheet?
Charge
He is A1 or A2?
charge sheet file lordship, it was not numbered.
What numbers? What exactly is the allegation against this man, owner of the car? Mr. Mujib.
My lord, page 11 of the count. It's
Correct. We are at 11 only.
yes, my lord. Lord, 120 cases were seized from along with blue and brown colors
Seized from him or from the car?
from him, my lord.
Where is the FIR 76 of 2023? He is the sole accused.
Yes, my lord. I'll just submit it. Either,
Who is A2? So A2 is driver. He is one.
ఇది FIR 5 కదండి.
So this particular 120 case of ganja was recovered from the car. Yes, Mr. Mujib, page 20, 21.
FIR ready?
FIR is at page 21.
I'm sorry, my lord, I could not.
What about bail, madam?
It was granted.
Any condition imposed?
Conditions, he should, rotate years within the 10 to 12. Yeah.
What is the name of alleged detainee?
Chekka Kumar. Chekka Kumaraswamy.
A1, my lord. Kumaraswamy Chekka.
Kumaraswamy, check up. A2's name? Ravina? Mohan Dupati.
Dupati Mohan.
So he is the driver.
Yes. A3 is
What about
Ganesh.
history? A3?
A3 is Ganesh, my lord.
Who is A3 then?
Ganesh.
Who is he? What is the allegation against him?
But I'll read the FIR.
What is the allegation against A3?
A3 allegation there was.
Where is the charge sheet?
Charge sheet is at page,
But page 26, my lords, may kindly see the complaint.
We are at 26 only.
26, middle, my lord.
Hmm.
Almost 10 lines from bottom. On that, he revealed his name as A1 Kumaraswamy. And further, A1 confessed that for the livelihood, he purchased a car from his brother-in-law and running it for rentals and not satisfied with his earnings, he decided to earn easy money. For in the past 8 years, he has been purchasing ganja, dry ganja at cheaper rate from Kalimela of Odisha state and selling them.
How many cases are there against him? Only
History,
this is the only
3 cases are. Ground case is only 1 case, my lord, but history 3 cases are there.
3 cases.
3 cases.
In 3 cases, Lordship, 2 cases are from our Telangana state and 1 case is of Maharashtra.
మరి మీ వాడైతే బిజినెస్ ఉన్నాడు ఈ పని చేస్తూనే ఉన్నాడు కదా సరే మీరు కొట్టేస్తున్నాం ఇప్పుడు కానీ
He is a driver of an auto
who is driver
A1
earlier
earlier.
now he has purchased car
But his,
by selling the ganja
just for his daily needs, he used to drive his
we are granting we are now setting aside the order but you have to tell your client he has to go one day or the other from 2020 onwards he is in the business.
He is the driver, Lordships. In past 2 cases, he is the driver of his own auto.
First case 180 of 2020 174 case of ganja
In these 2 cases,
13 lakhs 90 ఇంత కాస్ట్ ఉంటుందా
Yes, very
13 lakhs 92,000
It is running.
second case 242 case of ganja.
Let's see, we have given the value at pages 10 and 11 of the count. In the ground case, it is 24 lakhs worth.
24 lakhs and got point stage.
Going for respond number 3, my lord, we filed a counter. Yes, madam, file. No problem.
Yes, mister, not received.
Not
Why don't you tell us? We will direct him to serve. Why these things?
I'm ready to argue as well.
Please argue
Yes,
without
sir.
counter.
My
Without
lord,
going through the counter.
I would like to go through the counter, but there is an urgency. in
One
this-
second, who said we are not saying anything?
Yes.
You want to argue without going through the counter, is it so? Then
Direct.
what is the urgency?
My lord's 92-year-old father, my lord's. He is
92-year-old father is with,
with the younger son, my lord. I'm
Younger
the elder son.
what is the urgency?
My lord's his health is deteriorating in a very drastic manner.
Hmm.
And at least he needs to be sent to a hospital, my lord.
Which hospital?
Usmania
Do
Gandhi.
you think that younger son is not taking?
He is
care
not
of the
taking
father?
care. He is not taking care of the father. They are only looking after his BP sugar medicine. He is suffering from dementia and
What is
Parkinson's.
dementia?
Vascular dementia and Parkinson's, my lords.
Hmm.
His nervous system is completely damaged and he needs proper medical assistance, my lords.
You are doctor.
I am a doctor. My wife is a doctor. The detainee himself was a doctor, my lords.
Hmm.
This person is a business person,
Hmm.
and his motive behind all this is to transfer some properties to himself. That is secondary issue, my lords. My only concern is with regards to the health of my father. Even if he is directed to take him to a hospital, Usmania or Gandhi, immediately.
Do you have extra copy of the counter with you? Counter వచ్చిందా మంది? Where did you mention about the treatment of your father? Details of treatment and will deeds we are not concerned today. What is this WP 14233 of 2023? Narendra. Who filed? Seek, what is the relief, sir?
Seeking serious back.
Hmm.
We filed a counter there saying that the petitioner
What happened to that petition?
is not getting any order.
It is pending still. Where is that order?
Yes. Order withdrawn.
First, let us see the relief, sir. Writ petition.
Previous.
No, previous writ petition.
Page 63.
63 is your counter.
63.
Is your counter. Who filed this OS 29 of 2022?
Myself, my lords.
Page 17. Is
Page?
page 70.
70. Where is the relief portion? This is counter, mister. You have not, it appears you have not filed. Where is the order at least? Order passed by this court in the earlier writ petition.
Just pass it over. No? Submit.
Relief is not there. It's a appeal. And counsel for petitioner has filed a letter before registrar judicial seeking submission of this court.
Page 84, man. The relief is at page 84.
84.
Sorry, man.
84.
84. For the reasons stated in the accompanying affidavit, it is therefore prayed that this honorable court may be pleased to issue an appropriate writ order direction more particular and mandamus in not acting upon representation dated 28/3.
Who is
This is
second respondent? Who is
here the second respondent is the family, the welfare, district welfare officer, women, child, disabled, senior citizen. Given by the petitioner hearing seeking the custody of respondent number 3 and 4 parents who are suffering with multiple health ailments. And he mentions what vascular dementia, Parkinson's disease as being.
Mother is also with you.
Now mother is no more. She was with my sister, with our sister, elder sister. Now she is no more.
She is no more.
She is no more. She is, this was, when the writ was filed, pending the writ, she expired. They see very senior, at the age of, yes, ma'am. At the age of 89, she passed away.
Anyway, age is mentioned as 85.
Yes, ma'am. And in this manner, we had filed our counter. The writ itself was not maintainable because under the act, it has to be filed either by the parents, by the senior citizens or the persons who are requesting for
Who filed
aid.
this suit? YS 82?
Suit also filed by the petitioner
What is the relief suit for?
for cancellation of a gift deed which was given by my father to me, and now they have said that that gift deed was issued or executed.
Did you mention about the treatment particulars
Yes, ma'am.
of your father?
No, at para 7
7 of your count.
of my counter, madam.
Please read.
I've said the petitioner is a disgruntled son who severed his ties with the family and is living separately
Where is
since
he reading?
95. Para 7, my lord, of the counter. Page 7, I'm sorry, ma'am. Page 7, para 7 continuation. In this fourth line from the top, madam. Petitioner is a disgruntled son who severed his ties with the family and is living separately since 95. The registered will of 96 itself disclosed that the petitioner has broken away and is living separately. There were 5 wills in all, my lord. My father executed 5 registered wills and he is not there in any of them. The most recently registered will dated 14/9/2019 also clearly disclosed that the petitioner is living separately and that I, along with my family, am living with my father.
I am only
I am
taking care both medical and personal.
and of my father. Also registered itself squarely evidence that my father and I have a
The
very
bills were executed in the year 1996.
96 onwards, 5 wills till
Recently-
2019.
Recently, you have not obtained any bill from your father,
2019 is the latest will. 5
2019.
2019,
not in 2023.
not in 2020.
You know why he has filed this writ petition on the earlier writ petition?
Now he's aggrieved. He's aggrieved that my father executed a gift deed now in my favor. And he's filed a partition suit in.
Second, that is factual incorrect.
No, he executed a gift deed.
Which date?
The gift deed also, my lord,
That is his apprehension. No love affection on the father.
exactly, my lord. I have stated, in fact, all that sudden love and concern at para H at page 4, I have said.
What is the
gift
want
deed
the number,
number
gift deed number as well as date?
29/8/2022.
29/8?
2022 at para page 4, I have said so.
2023, sir.
2022.
2023.
29/8.
You have not obtained any.
No, not 2020.
How many properties are there in your father?
One property.
More.
No, only one. Nothing more.
He has already executed gift deed.
Registered gift deed is executed. Now that I have disposed that of, your lordship will see page 4, I have stated so. All his love and affection comes now, after 1995.
So therefore, let us not acquire properties. That will create problem to us.
Page 4, my lord.
1 second. Mr. Farhan, please collect copy of the contract. If you want to file any reply to it, file it. We will, if according to there is an urgency, we will list it tomorrow itself as
And
a
my lord-
special case. 1 second.
Yes,
In the meanwhile, collect right now. If you want to file any additional affidavit, reply affidavit, file it
Yes,
tomorrow.
I'll file it tomorrow and place it before your lordship, if necessary.
Done. With request of Sri MD Paramkam, Land Council.
Rizwan, my lord, Rizwan representing on his behalf.
You are Mr. Rizwan?
Yes.
Mr. Rizwan, Land Council representing Mr. MD Faramkam, Land Council for petitioner, to file reply to the counter filed by third respondent listed tomorrow. In the meanwhile, Sri D. Navinda Naik, Land Council of petition, third respondent shall serve copy of the counter to Land Council.
Obliged.
Obliged.
Lordship, I'm representing on behalf of Sai Charat, Lordship.
Sai Charat.
Yes, Lordship. I'm representing in this case. Lordship, in this case, we have filed our reply, Lordship.
Filed reply?
Yes, Lordship.
Pleadings are complete. Pleadings are complete.
Yes, Lordship.
Yes.
Now,
Take your seat.
Yeah.
Yes, please.
Yes, Lordship. Lordship, for a moment, Lordship, kindly take up the counter filed by the respondent number 6, para 5, Lordships.
1 second. 1 second. Who is the petitioner? She
Yeah,
is the
petitioner is the mother, Lordship.
Who is the father?
Yeah, mother of the
That is
5-year-old child.
Father is sixth respondent.
Father is 6th respondent, who is the AIDS patient. Because of his health conditions,
What is the age of the boy?
14 years old child. 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 14 5 years, lordships.
5 years. Where is he now? Where is he now?
Now he is with respondent number 6.
Respondent number 6.
Yes,
Since how long?
for last 1 year, lordship. Before
is
1
that
year, both mother under the custody of both mother and father.
Boy is with the 6th respondent since last 1 year.
Yes, means for last 5 years with them only. But 1 year back, petitioner was thrown out from the matrimonial house of the respondent number 6 and they are looking after.
And then what is that your client is doing since last 1 year?
No, yes, many more discussions and deliberations have been done. But when there is no proper remedy from them, as there is no other alternative, they have approached this court. The whatever I am submitting, lordship, I am requesting to see the para number 5 of the counter affidavit to substantiate my contention, lordships.
Filed by 6th respondent.
Yes, lordship, para 5.
Please read.
Yes, the bona fides of the petition number, respondent number 5 shows, lordship. Your lordship kindly see. This boy was taken over by the petitioners and respondent number 6 by way of adoption deed at the age of 5 days. At the age of 5 days from the natural mother, the boy was adopted by the petitioner and the respondent number 6 because in future they do not have any proposal to bless with the children because of his health conditions. Now, the true colors I would like to bring to my lordship notice, para 5.
Read.
It is not way to mention here that the respondent number 6 had one brother who is also married but has got no issues. Though on the paper as a formality, the child was adopted in the name of the respondent number 6 and the petitioner, but the petitioner never cared to look after the child properly and the child was brought up in complete sense by the brother and his wife of the respondent number 6. The petitioner was leading a life of visitor with the respondent number 6, coming and going as per her own wishes, and whenever she used to come and live with respondent number 6, she used to take away his hardly earned income and running from his pocket and even demanded to pay the amount so and so. Lordship, 2 points I would like to agitate from this para. Clearly, respondent number 6 himself accepted the boy has taken over by his brother, not by himself, is not totally correct. They have created this story for the purpose of come over of this writ petition. Number 2, with the due respects, I am not commenting about the employment of the respondent number 6, lordship. He is an auto driver. So what extent the person is earned the money and to what extent have dragged the amount from him? With the due respects, I am not commenting, lordship. As per the contents mentioned in the counter affidavit only, I am agitating before this honorable court. By and large, my question before this honorable court, lordship, allegations, counter allegations, this is not the forum.
1 second, where is this MOU?
Yes,
31/10/2008.
Yes, lordship. Yes, lordship. Lordship, kindly pick up the main writ petition, lordship.
Page number?
Yes, lordship. I am coming, lordship. Page number
32.
32. Yes, lordship.
Let us see this.
Yes, lordship. Page number 30. Kindly see that purport of the adoption deed, lordships. This is between Sujata Sharma. Your lordship got it?
So adoption deed is dated 30th of May 2019.
Exactly, lordship.
This MOU is dated 31st October 2018.
No, not this yes, lordship. This MOU I would like to bring to my lordship's first instance. The MOUs between Satish Sharma is respondent number 6 and Sujata Jadhav is petitioner, lordship. Kindly the contents. First party and second party are husband and wife respectively, having been married at Rambak so and so on July 2/17. And the said marriage still subsisting. The marriage was performed in accordance with Hindu Vedic and rites. But from last 6 months, there are some disputes arose between two parties. The disputes not yet settled, even though in spite of elder settlement. As such, they have decided to live separately to break their marriage. That on behalf of Satish Sharma and Sujata Jadhav, the above parents have come an understanding to break their marriage so and so. Lordship, having come to know about his ill health.
1 second, Mr. This MOU is dated 31st October 2018.
Yes, lordship.
On which day they have decided to live separately?
Yes.
Since 1 second. Since how long they are residing separately?
No, during period they have to live separately, lordship. Till they have executed the adoption deed.
So 30th of May 2019 is the adoption date.
Yes, 30th onwards to April, lordships.
From 13th May 2019, they are living separately.
Yes, no, sorry, lordship. This executed on October 18th onwards, till April 2019, they have lived separately.
April 2019.
Yes. That time, during the intervention period, the elders have advised him that they have admitted in their counter affidavit, Lordship. Better go for adopted child because it is not healthy to have your own child. In those circumstances, this May 19th, from the natural mother, that time the boy age was 5 days, they have taken the child. Lordship, permit me to read the contents of adoption deed for a moment.
Page number
Page number 33, Lordships.
33 is adoption deed.
Yes,
Adoption deed, anyway, we have gone through this.
Yes, Lordship. The adoption deed purport, the Rajalakshmi, who is the natural mother, given adoption, her child to these parents. This the parents means adopted parents. Contrary to this, in counter number para 5, that respond number 6, they have taken for the sake of his brother, he has no issues. Lordship, kindly see the boy is not a toy. As per their whims and fancy, they have to take adoption deed and give to somebody. Lordship, I am before this court is only one question only, Lordship, I want to agitate. The paramount interest of the child is the important aspect with whom he has to be. Lordship, allegations, counter allegations have in number. Respond number 6 made so many allegations. She has given 50,000. I have taken 50,000, hand over the child. I am not at all on that
One second. We are also not concerned with all those things.
Yes, Lordship.
Please answer only one question.
Yes, Lordship.
Since how long petitioner and sixth respondent are staying separately?
For the last 1 year, Lordships.
Tell us the month, date or year.
According to my information, she said February 2023, Lordship.
23.
Yes.
In MOU,
One
second. In MOU of October 2018, why they have decided to stay separately?
No, yes, exactly. I have mentioned in the affidavit. I'll also state my Lordship.
Where is the rejection in the affidavit?
1 minute, Lordship. Because of his ill health, they have decided separately. They want to go for divorce. That is the reason they have given MOU. MOU also purports very clearly the marriage is breakdown. After execution of MOU, both people were silent. They have not taken steps. Lordship, the relevant paras which I have mentioned in affidavit, permit me to bring, Lordship.
Please read paragraph number 8.
Yes, Lordship.
Paragraph number 7 is with regard to MOU.
Yes, Lordship.
Read 8.
I'm coming, Lordship. Just bear with me, Lordship. Yes. Para number 8. I submit after the execution of above MOU, both the parties had lived separately. After span of 6 months of their separation, however, they have filed any petitions. They have not, Lordship. By mistake, there I have to put not. My yes, Lordship, I understood. I have realized I made in my correction in the affidavit, Lordship.
Right. No problem. That is not.
Yes. With due apologies. I supposed I made in my paper, Lordship. It is a typographical mistake. They have not filed any petitions before the family court for obtaining divorce. As such, in these circumstances, with the intervention of the family members and well-wishers, made efforts to reunion and suggestions had been given to the petitioners and husband. Instead of breakdown of their marriage, it is advisable to adopt a child who belongs to a poor community. Therefore, it is appropriate to provide a better life to the child and also to their family. The petitioner and husband respected the advices of the family members and they were reunited. I submit that the petitioner and unofficial response 6 made their inquiries to make an adoption a child from poor family, preferably a just born child with an intention from the day one. The newly born child is convenient to look after the child as if the petitioner and the unofficial respondent are the parents of the child. Lordship, I am very conscious in my pleading. There only I heard a small word missing. They changed the entire scenario. In this backdrop, Lordship, the child was taken for adoption.
Please come to paragraph number 12.
Paragraph number, Lordship?
12.
Yes, Lordship. Yes, Lordship. I submit that in these circumstances, as a vengeance that the unofficial respondent could not tolerate the acts of the petitioner, and more particularly as she is restraining the unofficial respondent either to interact or closely move with the child. In the month of February 2023, the unofficial respondent number 6 thrown away the petitioner from his marital house, keeping the custody of the minor child with him. The petitioner and his family members made several requests to the unofficial respondent number 6 to give the custody of the petitioner mother as he is so.
One second, Mr. Raghu. We will hear sixth respondent.
Yeah.
What do you say on your disease? According to the petitioner, you are suffering with.
That is an admitted fact that he was suffering with the disease. So after knowing the fact, they both have decided to separate each other, get separated. And for that reason, they have entered into an MOU and they got separated. After getting separated also, she did not choose any way out to get divorce from the concerned court. And she did not take any steps also. And she herself, in the petition itself, it mentioned that she herself has come back to the respondent number 6. It was not the respondent number 6 that he has called her or anything. She herself has come back. It is mentioned clearly in their
Thereafter they have gone for adoption.
yes,
That is also not in dispute.
that is also not in dispute. That adoption
And
was,
what is the age of the boy?
the age of the boy is now presently 5 years.
5 years.
Now, at least it is almost
So
1.5 years.
One second, it is a tender age?
It is a
Yes or no?
yes.
So tender age boy should be with the mother, not with the father.
Yes, no. But now it is almost 1.5 years that she has left the board. For this 1.5 years, who is looking after the child? She did not care for that child for 1.5 years, this long period. And now all of a sudden she is coming and saying that she wants the child. And she is finding this type of petition. She actually 2 days back also, that is off the record. She is clearly asking, demanding amounts for that. And in the month of August, she left the
How much?
50,000 she has asked.
Only
If my
50,000.
sister says like that, I have also enough
No,
evidence.
in the month of November, she has received 50,000 rupees from this respondent number 6,
November 2023 or 2020?
November 2022.
So you are an auto driver.
She is using that boy as a blackmailing tactics, whatever it may be said, because she knows very well. If she is thinking of the welfare of the child, she would not have adopted the child first of all, because he's suffering with this disease. Okay, when they have adopted, she should have seen the child very well. And she
One second, what about your parents?
parents,
Your parents,
yeah, the parents are the one who have
sixth
got
respondent parents.
6 respondent
So
parents.
he has both parents.
He is also present.
No, not necessary. Their presence is not necessary. No.
They are looking after the care, and they are the one who has conducted all mediations and everything with the natural mother, and they have requested the child for this adoption. And they have seen, by seeing their respectable family and everything, by seeing that the child will be looked after properly, she has given in adoption to this person. By seeing the father, parent of the respondent number 6, not to the respondent number 6 or his wife.
But both of them are fighting. What to do?
Both of
Boy is suffering.
But that,
Adopted boy.
from day one, my lordship, from day one, the brother and wife who has not got children, that is an admitted fact, they do not have children. He is the one who is looking after everything, from medical care, to brothers, wife and brother. They are also staying in the only one family. Because he was suffering with this disease, they were made to stay in the first floor of the house. That house is a known house, she also knows that. Petitioner knows that house is a known house. And apart from that, she comes and she goes like, she is coming and she is going as a visitor to the house. She herself, she is just defaming this person everywhere that he is suffering with this disease. Okay, admit it. When you know very well that she is differing, he is suffering with this, but then why do you come and why do you go every time? Every time she comes and every time they have also now at this moment also, it's 1 week or 15 days back, she showed her willingness to come back. So he got understanding again that you will not go back again every time and go and back. Because
Papers writing something in on paper will not work out.
yes,
Staying together is altogether different.
yes. When she did not go to the child for all,
1 second, why they are entering one agreement after the agreement, MOU, adoption deed, second MOU, third MOU? That shows their conduct, attitude. If they are not interested, let them obtain decree of divorce and stay separately.
my client is going
So then why you are asking for one more MOU?
no, because she is willing, she is showing the willingness, she is calling him.
If she is willing, she can come and join the sixth respondent. Here is a question of entering MOUs. What for?
That's what I have also
And notarized MOUs.
advised.
You don't have confidence on each other. Notary shows entering MOU and notarized MOU.
It is that this is.
Anyway, we are reserving, Mr. Raghu, we will pass orders.
I have advised.
We are reserving.
Lordship, one answer only, Lordship. The counter affidavit para 5 gives lot of weightage. He made it very categorically for the sake of son. Tomorrow, by any chance, if son is going to bless with children, what about the fate of this child, Lordship?
Don't ask us questions.
No. I'm putting on my own,
Questions
Lordship. I'm
to the
sorry.
court.
That is not my intention.
Lord Sri M. Raghu, Lang.
Lordships, may I permit you to withdraw this writ
Why?
petition?
PD Act.
This got
Production of petition, different, not PD Act. Hey,
already remanded, Your Lordship.
302. Or Soumya Reddy, learn counsel for petitioner, 6. Permission of the scope of the presented petition. Permission of the accorded, writ petition is dismissed as written. 302, read with 34. Yes.
This we are filing counter today, Your Lordship.
16. How many cases are that?
4 cases out of 4 cases. Compared to previous case, 19.
At the request of land owner, trusted owner, paid for file counter list on 16.
This also we are filing counter today.
How many cases are there?
Solitary case of folks.
So, Your Lordship, all remember, also case. Yes. Victim is 11 years.
Team is,
11 years, Your Lordship.
so this we will list it on Tuesday. At request. Tuesday.
16, Your Lordship.
What is the problem in filing counter?
Lordship wants to hear,
PD Act and your
Lordship want to hear the matter, Lordship. That's why.
on 14th itself. Solitary claim. What about your bail?
Bail, it was not granted. And he does not have any history on some
Huh.
lordships. He does not own.
He is also admitting that only on solitary crime.
May kindly post it tomorrow, lordships.
Tomorrow is not possible. Date of what is 19/4/2023. What is the stage of investigation? That also you don't know.
Investigation also.
How many bails you have filed so far?
3,
3 bail applications were dismissed.
2 were dismissed and in the
Third is pending. So then we will list it on 16. Suppose we set aside also, it will not come out.
He-
If
uh,
bail application is pending.
19/4 order has been passed, lordships. Before 15 or 20 days, before passing of this detention order, he was being remanded, lordships. He was remanded.
Ultimately, he has to get bail.
I'll get the instructions.
Huh?
I'll get the instructions that he has.
At request of land assistant government creator, the file counter list on 16th November.
These all matters are listing counter. Send for signatures, Lordship. Send for signatures.
Present is Chandramohan.
How many cases are there?
There are 2 cases, ground cases.
Offences?
Offenses, one is Milashi 302 is accused number 6. Another they have mentioned Milashi is not accused.
Is not an accused.
Not accused.
It is total 9 accused. These are 4 years. Now,
16th.
guys.
Assistant government creator, the file counter list on 16th.
Right. Wait, please.
In this recent instructions about the health sanction of A1 and A15.
A1 and A2. 15.
A15 is also stable or had done surgery previously is stable now. A1 is also stable.
Surgery for
Surgery for hernia.
A2 and
A1 the mental condition was not at the time of admission, now it stays.
medical certificate dated 7/11/2023. This is of A1 or A2?
A1 your Bode Bhaskar.
Bode Bhaskar is A1, right?
A1.
he was sent to Institute of Medical Health, Telangana, for his complaints of abnormal behavior. He was diagnosed as, read,
And
bipolar affective disorder.
mental health Eragata on 7/2/2023 for his complaints for abnormal behavior. He was diagnosed as having a bipolar active affective disorder, multiple episodes, currently mania with psychotic symptoms. At the Institute of Mental Health Eragata, he was treated for the same and shown improvement, followed by discharge on 25/5/2020. Presently,
This is A1.
on medication.
A2,
A2 is
Chinna Venkat.
Nakala Chinna Venkat. He was known as a hypertension on regular medication. Presently, he was diagnosed as having Lonis grade 2 ventricular arrhythmia of 5 Holter ECG recording on 3/7/2021 at NIMS Hospital, Banjapta. He went for repeated follow-up checkups for his chest pain at NIMS Hospital and advised medication. He was also sent to gastroenterologist pulmonology departments of Gandhi Hospital for his complaints, epijac pain and cough, medication given, history of right oricostomy done 7 years back following trauma.
Date of judgment?
My lord,
Date of judgment.
date of judgment is in the month of, in the year 2016, my lord.
Date చెప్పండి. We are asking you the date specifically.
Date of judgment.
25th September 2017.
25 of September
So from
2000.
25th September onwards, he is in jail.
Yes,
Who are in jail?
yes, ma'am.
All three of
Yes, ma'am.
will decide the application, bail application.
Much of. So with regard to the their conduct in the prison, my lord, with regard to their conduct, my lord, they were granted parole for 3 times, my lord.
That is not in dispute.
Yes,
With regard to
That is not the problem. There is no complaint against all three of A1, A2 and A2. Anyway, A15 is suffering with hernia problem.
yes, he is suffering from hernia problem, my lord. And one humble submission is, my lord, age is given, your lordships may go through volume 1, first page, my lord. Age is, he is, right now he has completed 60 years, my lord.
A15.
A15, my lord, it is given mistakenly as 56 years, my lord. Because in the charge sheet itself, it is clearly,
Second. He has completed 60 years.
yes, my lord, that is my
And he is suffering with hernia.
hernia.
Date of judgment is
25,
24th September 2017.
2016, my lord.
2016.
16, 17, apologies. 17. 16 is deposition.
So three grounds. One, Pachurangara of criteria.
Yes,
2, he is suffering with health issues.
yes,
3, is a senior citizen.
yes,
Apart from that, there are no specific allegations against him, etc.
yes.
In minutes.
And
This is with regard to A15.
if,
A1 and A2, health grounds.
yes,
And Bachurang,
yes,
right?
yes. So on merits also, I'll make my submissions. So with regard to the A15, my lord, and also your lordships may take note of the fact that accused number 22, his wife is his wife, my lord.
22.
Accused number 22, and she
22
died.
is wife of
A15.
A15.
Yes, ma'am.
So
And-
she was also convicted by the trial court.
Trial court and
So now on bail.
no, my lord. She died in the year 2021 December 26th, my lord.
Sir, appeal ఏంటి? This appeal is filed by even A22.
Yes, my lord. Even 822 is.
So then we have to.
But counsel is Mr. Kiran Palakurthi, my lord. But only to bring to your lordship's notice that the family.
Kiran Palakurthi, land counsel for చెప్పండి. Recent, కదా? Recently. Yes, Kiran. 22 we have to abate. Kiran Palakurthi and against 22 was not, the appeal was not abated.
Yes, ma'am.
Is it not?
Yes, ma'am. Because as I'm not the counsel on record, I may not.
One second.
Well,
This court wide order dated so and so, granted interim conditional bail to A22, up to so and so. Death was not brought to the notice of this court.
yes,
And we have granted interim bail to her twice.
yes, madam. She has taken treatment at Usmania Hospital, my lord, but subsequently due to lack of proper care and attention in the prison Chenchalguda, my lord.
No. On 23/8/2021, there was a submission saying that she was admitted in Usmania.
Well,
She was on dialysis,
Yes.
condition is critical, etc.
yes,
But death was not brought to the notice of. 27/12. Accused 15 or 22. Death was not brought to the notice. Anyway. Eight 22 parents. 820, what is the name of 822? Wow, Makkala Lakshmi.
Lakshmi, madam. Makkala Lakshmi.
8 against law. Yes, yes, Mr. Person.
Well, wait, please, my lord. With regard to the mental health conditions, my lord, with regard to A1, my lord, I'm relying on one judgment laid on with the Supreme Court, my lord. This is a judgment rendered in the context of post-conviction mental illness, where accused was awarded death penalty by the trial court, and it was
Manoj, state of Madhya Pradesh.
no, my lord. Accused X versus state of Maharashtra. Accused X versus state of
State of
Maharashtra.
We are aware of that judgment anyway. We are hearing 8th death penalty matters, right?
Yes,
One matter since last 36 days. Today we are going to conclude,
ma'am. So,
hopefully.
so my lord, my submission is
What is the principle?
principle.
So at any stage,
No, madam.
even while hearing the appeal or after confirming the conviction, we have to appoint a mitigator
Yes,
for the purpose of assessment of the accused.
yes,
So
madam.
that is the principle laid down by Supreme Court.
Yes, madam.
After this, there is one more judgment.
Madam.
Manoj,
Yes,
it was referred to 7 judges bench.
madam. So,
Even in 2 matters, we have appointed mitigators.
yes,
The students who are attached with Project 39 Caption League.
yes. So with regard to this judgment, my lord, what happened is the trial court has awarded death penalty, High Court has confirmed it,
Correct.
and Supreme Court has also confirmed it. Subsequently, in the review petition, Supreme Court has commuted the death penalty to life imprisonment. With regard to the legal position, my lord, the judgment may not strictly apply to
What is
case.
it we have to do? Tell us.
Yes, my lord.
We have to assess.
No, what is my submission is with regard to the conditions in the prison. So with regard to the general observations that are made, my lord,
Conditions in prison, we are aware. We are visiting the prisons regularly.
Yes, ma'am.
All High Court judges.
Yes.
And also Secretaries Legal Services Authority.
Yes, ma'am.
They are visiting fortnightly once.
Yes, ma'am. Para number 45, my lord. It is pertinent for us to understand the phenomena.
We are aware of this.
Yes. Coming to the next aspect, my lord, your lordships has passed an order.
Secretary
Sir, my lord, with regard to the legal position, whether a life convict who is accused of specific overtax, can he be enlarged on bail? That is the one principal question, my lord. And the second,
matter which you have argued.
yes, ma'am.
We have discussed.
Yes, ma'am.
We are aware.
So one legal aspect, my lord, that is page number 7, my lord. Page number 7, my lord. That is at para number 9, my lord. So,
Anurag Patil.
yes, Anurag Paita, my lord, in this para number 9 of your lordship.
You are aware, Mr.
That paragraph I may be permitted, only one.
Not necessary, we'll consider.
That man, because the law is, my lord, in the initial stages, it is true that if accused, a life convict, if he is accused of primal role, my lord, the courts would not be inclined to grant the bail, my lord. But if the appeal is pending and if if he is in prison for more number of years, my lord, certainly he can be enlarged on bail. That is the legal position, my lord. That is one aspect. And one specific judgment, my lord, wherein despite specific overtax, the Honorable High Court, when the Honorable High Court has enlarged the accused on bail.
What ground?
On the ground that, no, my lord, on the ground that pending appeal is pending before the court. So, when the de facto complainant has approached the Supreme Court has dismissed the appeal, and while confirming the High Court judgment, my lord.
Granting bail.
Granting bail. Yes, ma'am. Para number 4.
High Court was granted. High Court granted bail to him.
It is in the
or on merits.
On the delay, my lord. Delay in the
delay in disposal.
Yes, ma'am.
We have considered all those aspects in your order.
Yes, my lord. But because with regard to the because this is a case where accused is attributed specific role of specific overtax.
We will consider that, Mr.
Yes.
Next.
So that is para number 4 and 18 in the judgment, my lord. Coming to the merits of the case, my lord, the witnesses, the prosecution witnesses, whoever have deposed before the court, my lord, they are clearly tutored witnesses who have consistently improved their version before the court, my lord. More particularly, your lordships may go through the cross-examination of the
PW.
Page 75 of volume 1, my lord, PW 25, my lord.
Volume 2. Only one. There is only one volume. There are two volumes according to.
Yes, ma'am. 2 volumes are there. I have got
volume 2 and the second volume.
Volume 1, ma'am. Volume 1 itself, page 7.
Volume 1 is not with us. Page number
75, ma'am.
There is not. Volume 1 is not with us. I think there is one more appeal, right?
My lord?
There is one more appeal.
No, there are connected appeals, my lord, 1188, 1194 and 1359 of 2017. All these appeals are connected appeals.
174, 539 and 438.
Yes, my
right? Meeta Batla Vinayas. Volume 1. Right. First copy. Page number
75, my lord.
75 is inquest report, P9.
No, my lord. Page number
you are reading PW?
PW 25, my lord.
21st deposition.
Yes.
PW 25 deposition is not there. Volume 1 is the first copy on like that. Read.
It is true that when there is cross focus of headlights of 2 vehicles, when a person may not be able to see the inmates of the vehicles clearly. On seeing the tractor, some of the inmates of the forest jeep got down. It is true that PW 1, 2 and 3 have not stated before me the specific overtax of accused 1 and 2. So it is clearly a case of improvement, my lord. So your lordships may take note of the fact that the incident happened on the intervening night between 14th and 15th of September 2013, my lord. So they deposed before the court for the first time on 4th April 2016, my lord. So there is a time gap of 2 years, 6 months and 20 days, my lord. So it is clearly an improvement, and they did not state the specific overtax before the investigating officer when they were examined, and they stated for the first time before the court, my lord. So it is clearly an improvement on the face of it. That is one aspect, my lord. And second aspect, your lordships may go through in the same page, my lord. And even in the earlier bail petition, in the earlier order which your lordships have enlarged the other accused, my lord, the investigation officer has clearly stated that no test identification parade was conducted in this case. I have not inquired into the land disputes of Raghunathpalli village. I have not filed any proof before this court to show that the land belongs to the forest department. And next page number 77,
Your Lordship,
We are following you.
My-
Volume 1 is not with us.
then your Lordships may,
May?
without the volume 1,
What to do now? Volume 1 is not there, you are arguing.
no,
We will hear you and we will get the book and we will decide the bail application. Otherwise, we have to adjourn it by Tuesday. Monday is a holiday. Choice is yours.
because there are depositions, my Lord.
What to do? Book is not there. So you have read PW 22.
PW 35, my Lord. PW 25, my Lord.
25 we have, page 58.
Yes, my Lord, your Lordships may,
Page 58.
yes, my Lord.
70. Yes.
Yes, my Lord. It is PW 25, my Lord. On the deposition internal page number 3, my Lord.
Read.
Line number 10, my Lord. Line number 10, my Lord.
Yes. Yes, Mr.
Yes, ma'am. It is true that when there is cross focus of headlights of two vehicles, a person may not be able to see the inmates of the vehicle clearly. On seeing the tractor, some of the inmates of the forest jeep got down. It is true that PW 1, 2, and 3 have not stated before.
He is the investigating officer.
Yes, ma'am. So he clearly admitted that witnesses did not state before him with regard to the specific overtax of A1 and A2. It is true that the description of sickle MO3 is not given in the recovery Panchanama. And with regard to the sixth line from bottom, my lord, no test identification parade was conducted in this case. I have not inquired into the land disputes of Raghunathpalli village. I have not filed any proof before this court to show that the said land belongs to the forest department. And the deposition of the same witness when he is recalled, my lord, dated 23/3/2017. MOs 2 and 3 sent to FSL for analysis. We have not collected any fingerprints on MOs.
Yes.
I have not conducted any identification parade with witnesses to identify the culprits, more particularly accused persons. So my submission is, my lord, in this case, even accepting the evidence of the prosecution witnesses to be true, my lord, identity of the accused is not established clearly and more particularly beyond reasonable doubt. And the law is very well settled with regard to the identification of the accused, my lord. That is, identifying for the first time in the court is a weak piece of evidence, my lord. No conviction can be awarded basing on the identification for the first time before the court, my lord. And if at all, that any conviction can be awarded, my lord, what has to be seen is whether the witnesses have stated any particular distinguishing features of the accused.
Prashant, you are arguing only bail application, not the appeal.
Yes, well, because the identity.
So identification is a weak piece of evidence, leave it there.
Yes.
Don't go further.
Yes.
Reserve your energy, you have to argue appeal. Next ground.
So with regard to the identification aspect,
you have finished.
Only two aspects, my lord. Whether the accused, neither the accused is identified, my lord, nor is there any identification of weapon being done, my lord. Because in this case, witnesses clearly they have deposited before the court, my lord. Deposition of PW2, my lord. Deposition of PW2, my lord.
What is this deposition?
That is, his deposition is, my lord. I cannot say the nature of weapon, more particularly axe, which is a general weapon used by everybody in my statement and evidence. I cannot say the nature and shape of sickle MO3. Myself and beat officer returned to our office. Later, we approached the hospital directly. I was inpatient for 3 days in government hospital. During the hospitalization, I was examined by police, but I do not remember the designation of the officer. So, my lord, no test identification parade being conducted and no.
Investigating officer has already admitted.
Yes.
There is no need to argue further.
Yes.
On that. Next.
Yes. In a similar incident, my lord, where the High Court of Karnataka has convicted the accused, my lord, when the identification is
No, no, keep it with you. That we will consider at the time of hearing of the.
no much of
bail application.
yes, my lord. This is
We
bail.
will consider your contention with regard to identification.
Yes, my lord, because the legal aspect that is involved in this case, because why I am stressing with regard to the identification aspect.
Identification, we are aware, Mr. Prashant.
My,
Don't cite any judgment.
much of,
We said we will consider your contention.
much of.
Next.
The lordships may go through the judgment of the
Judgment of
Sessions Court, my lord.
which paragraph?
Para number 27.
What is the finding? What is the finding?
Finding given, that is, my lord, with regard to the A15, my lord. Prosecution witness 1 did not state before the court, even before the court, with regard to the specific overtax of A15, my lord. Subsequently, the witnesses have stated before the court PW2 and 3 with regard to the specific overtax of the A15, my lord.
So according to that is an improvement.
Yes, ma'am.
We'll consider that.
That aspect.
Next.
And page number 30, my lord, 30 of the judgment.
Para page.
Page number.
Paragraph number.
Paragraph number 11.7. 11.7. The learned counsel for the accused contended that the prosecution witnesses have not given specific identity.
Don't read contentions, read finding.
Yes, ma'am. Because
We are reminding you again,
ma'am,
you have to distinguish the submissions which you are making in bail application and appeal.
yes, ma'am.
You are arguing bail application, you are arguing like appeal.
No, ma'am. My submission is
What is the finding given? Don't read the contentions.
yes, ma'am. Page number 31, my lord.
Paragraph number.
That is the second line, ma'am.
Second line of
Page 31.
page 31.
Yes, ma'am.
What is the finding?
Yes, ma'am. My endeavor before your lordships is not to appreciate evidence. Yes. So when a mass attack is being made, the identity of each accused may not
Identity you have already argued. You are arguing.
No, because the finding of the
Finding we will go through.
because my submission is, my lord, not to appreciate or reappreciate evidence, my lord.
We will not.
Yes, my lord.
We are considering bail application.
Yes, my lord. My only submission before your lordships is even taking the evidence of the prosecution on its face value, my lord. Identity is not established, and even the finding given by the learned sessions judge that identity need not be established is a wrong proposition of law, because the law is well settled, my lord, more particularly in the context of 148 and 149 section, my lord. Role of each accused need not be specifically stated, my lord, but the identity has to be established beyond reasonable doubt, my lord. In this case, more particularly, the accused and the prosecution witnesses are not known to each other, and when that is the case, my lord, when the forest beat officer is not a person who will be having the regular interaction with the villagers, more particularly the accused, my lord. So when that is the case, my lord, without undergoing the rigors of test identification parade and identifying a mob of 37 persons before the mob of 37 persons, and more particularly the accused 1, 2 and 15 among 37, without stating any specific distinguishing features of the accused, my lord, that shall not inspire any confidence before the that cannot be taken into consideration, my lord. And more particularly, the finding given by the sessions judge that identity need not be established in a mob attack is totally contrary to the precedents laid down by the apex court. That is one. That is a crucial.
After arguing 20 minutes, you say that is your first submission. Crucial submission.
Yes, my lord, because when the identity is
identity, we will not hear you further. Enough. Next ground. Tell us the ground, we will go through the record and we will pass orders.
Much only one final decision, my lord, only because it has
decision on
decision of Supreme Court, my lord, on with regard to the identification distinguishing
20 judgments right now. Shall I pick up and give you?
No, my lord.
Don't cite any judgment on identification. We have been telling you.
Yes, because my only submission is that has the direct
identified.
Yes.
Finding of the trial court is erroneous.
Yes,
right?
Yes.
Now take your seat. Yes, madam.
Much of.
Yes, Your Lordship, first of all, Pachulangana is
What is your standing, Prashant?
8 years.
Please enroll in the legal aid panel.
Much
We will appoint you as a legal aid counsel in 302 office.
much of
We are searching for good lawyers.
much of
Yes. Yes, ma'am.
Yes, Your Lordship, but Pachulangana will not attract in this case, Your Lordship, because it's a matter of the forest officer, Your Lordship.
So public up.
Public officer. And second thing is that, Your Lordship, about the identity of the accused, Your Lordship, in the evidence previously, they obstructed and previously 5 cases were booked on them.
It is this very same matter.
Yes, yes. And the evidence of PW1 on page number 24, Your Lordship. I have
Who
been
is PW1?
PW1.
Who is he?
PW1 and
What is his name?
PW1 is Mohammed
Cool. Forest beat office.
Forest beat officer. Only one line is there, one sentence. I can identify the accused.
Correct.
Second thing that I will read the evidence of PW2.
No. Who said about the previous attack? Or mentioned?
PW.
Who is he?
He is a driver forest.
Driver forest.
Have been working as a driver in forest range office of Indavali since 2012. The deceased Gangaya was our forest range officer. PW1 was our beat officer. LW3 Mohan was also beat officer. I can identify all the accused. There were 5 acres registered. There were 5 cases registered against the accused in our office and 4 cases registered by the police against the accused with regard to land issue. 5 days period to the alleged incident, all the accused came to our office, asked for the disputed land, and also fought with our
Anyway,
office.
next month.
That is the identity, Your Lordship. And there are specific overtax on case according to the evidence of PW1, PW1, 2, and 5, 6, 7, Your Lordship. PW.
5, 6, and 7.
Yes, Your Lordship. In this, they categorically stated specifically on A1, A2, and A15, Your Lordship. A1 wet the disease with the axe, and A2 with the stick, and A3 with A15 with the sickle, Your Lordship. And there is a recovery with regard to that also. That is recovery of the exhibit P20 is a recovery from A1, Your Lordship. P20.
Recovery from A1.
A1. That is the axe and a dragon light, and recovery of
Who is the punch for the recovery? Punch witness. Anyway, we'll go through.
yes, Your Lordship. Recovery of exhibit P21 is a recovery from A2, Your Lordship, and exhibit P90 P23 is recovery. 21 is from A2 and 23 from A15, Your Lordship.
20 from A1.
20 from A1.
A1. 22.
21 from A2.
21 from A2.
And 23 from A15.
23 from A15. Right.
And even it is supported by the FSM report exhibit P19.
Right.
And there is, in this case, Your Lordship, there is no need for TIP because already they are having quarrel, and they also made a dhana with accompanied by 30 people before this offense. Your Lordship. So there is no need for identification of the accused. Yes, sir.
And only one. Reply only for 5 minutes.
5 minutes. Reply.
As
bail application.
As early as possible, as quickly as. And coming to the prosecution witness, one statement.
PW1.
Yes. He says, I can identify all the accused.
Only one sentence.
Yes, ma'am. He says that he can identify the accused, but no description as to the distinguishing features of the accused was stated, my lord. And also he did not state that he knows.
That we will consult Mr. Prashant.
Much of.
Reply argument.
The reply to the argument, my lord. Page number 306, because that
306 of
volume 1, my lord. That is the FSL report, my lord.
What is an FSL?
Because the Leonard public prosecutor has said that exhibit P92 is marked as an FSL report. That is item number 7, 8, and 9. 1, 3, 7, 8, and 9. That is more particular.
1, 3, 7, 8, and
1, 3, 7, 8, and 9. More particularly, they are the material objects which are stated to be used by A1, A2, and A15 for attacking the deceased man. So, in that page number 2, it's clearly stated blood group of blood stains on item numbers 1, 3, 7, 8, and 9 could not be determined. So whereas blood group could be determined on all other items, my lord, blood group on why more particularly the blood group on the material object seized from the accused could not be determined. So it clearly, even otherwise, my lord, there is no clarity, my lord, that aspect. And with regard to the prosecution, because the punch witness for
Who is the punch for recovery?
PW 11, my lord.
BW level.
Yes. I may be permitted to read cross-examination. It is true that the description of MO2 is not given in the recovery punch norm. It is true that the descriptions of material objects MO 17, 18, and 19 are not given in the recovery punch. And more particularly, my lord, that is on November 6th itself, the Honorable Supreme Court has rendered one decision, my lord, that is Manjunath and others versus State of Kerala. In that it has clearly been stated, my lord, because your lordship asked me not to make any submissions with regard to the minutes, but because the learned public prosecutor has made her submission, so I have to reply. So it is clearly stated in that judgment, my lord, if the recovery is made from the open place, which is accessible to all, such recovery is not admissible or very weak piece of evidence. In this case, my lord, all the accused are villagers, my lord, and whatever that is recovered, that is axe, sticks, or sickle, they are the objects used by, it is found almost in every house of a village, my lord. And almost they are all recovered from the open places, that is houses and open places which are not particularly accessible only to the accused, my lord. So even the recovery aspect, it is failed, my lord. And more particularly, criminal rules of practice, rule 35 is not followed in this case. And also, witnesses have failed to identify the weapons in the court also, my lord. And there are consistent improvements in the statements of the witnesses, my lord. There, it is clearly a tutored, this is clearly a case where witnesses are all official witnesses and no independent witness is examined, my lord. So with regard to that non-examination of independent witness and failure of investigation, my lord, no conviction can be awarded. Only one decision I will submit and I will close.
Are you satisfied?
No, my lord.
Not for our satisfaction.
Because the reason why.
Because legal. Tell us the relevant paragraph.
Relevant paragraph is 6, 7, and 8, my lord. This is a case where in the state of Uttar Pradesh, an IAS officer was killed by the mob, my lord. The Supreme Court has said that presumption of innocence cannot be interfered lightly. More particularly when there is a cloud with regard to the identity aspect. This is a case where, my lord, even and also more particularly para number 14, my lord.
Para number 14 of
14 of the page numbers.
of Uttar Pradesh versus Rasified.
Yes, my lord. Para number 14, page number 6, my lord. And para number 20, 21, 22, and all the subsequent paragraphs, my lord. From para 20 to 26. So, my lord, only I may be permitted to read only one, or else I will leave it. I may be permitted to read only one sentence.
Sentence in paragraph number?
Paragraph number 25, my lord. Although we acknowledge the gravity of the offence alleged against the accused respondents and the unfortunate fact of a senior official losing his life in furtherance of his duty, we cannot overlook the fact that the lapses in the investigation have disabled the prosecution to prove the culpability of the accused. The accused cannot be expected to relinquish his innocence at the hands of an inefficacious prosecution which is ridden with investigative deficiencies. The benefit of doubt arising out of such inefficient investigation must be bestowed upon the accused. Much of.
Our person, one concept for petitioners, A1, A2, and IA 1 of 2020.
Yes, Lord.
Filed by
Filed by A2.
filed by A2.
A2. That is,
What about A1? A1 is in jail.
A1 is also in jail and he filed separate appeal and now bail application is moved on behalf of A1.
Date of judgment is 13th November 20.
Yes. 3 years, since 3 years, your lordship, the petitioner is in jail.
First bail application is second bail.
The second bail application.
Second bail.
Second bail application.
What ground you have?
The lordship, the A1, the deceased was the husband of A1. And there were some extramarital relationship between A1 and A2. That's the case.
A1 and A2.
A1 and A2. The entire case, your lordship, rests on circumstantial evidence. No direct evidence in this. Even the circumstance, your lordship, almost 16 witnesses were examined in this, your lordship.
19.
16 witnesses. Your lordship, PWs 3, 4, 6, 7, 9 to 12. Your lordship, they didn't support the case of the prosecution.
PW4?
PW 3, 4, 6, 7, 9 to 12. Have not supported the case of the prosecution. Have not supported the case of the prosecution. They were declared hostile. PWs 1 and 2 are the brothers of the deceased.
1 and 2 brothers.
PW 5 is the father of the deceased. PW 8, you notice, is relative of the deceased. Is a distant relative of it. Notice that the case is, you notice, on 4/5/2014. Notice in the midnight, you notice they were sleeping, and all of a sudden the deceased raised cries. On hearing cries, you notice PW 1 and 2 and others have come to the house of the deceased. It is nearby. Notice by the time you notice A1 was there, and the deceased was lying on the earth. PW 1 and 2, you notice did not refer the presence of PW in A2 anywhere. You notice further, you notice may kindly see that
Witness said
PW 8. PW 8, you notice. Last occasion, you notice I stated. PW 8 stated that the A1 was running away from the backside of the house. He saw the A1.
The vehicle.
Yes.
Vehicle is about.
Vehicle, not on vehicle. He was running away. A1 was running away from the backside of the house.
Let us see PW 8 evidence.
That's only sole circumstance you notice by the A1. PW 8 at page 27.
Please come to page 27.
27.
Fourth line. Fourth line from the bottom.
Yes, Lord.
Immediately I heard this.
I was under impression that they cannot notice.
Immediately I heard the shouts of PW1. Page 27, fourth line from the bottom.
Yes, Lord.
I found A1 cleaning the body with one cloth. I asked PW3 what was happened on that day.
Yes.
A2 stated so and so. Immediately I went backside of the house of Narsimha. I found accused number 2 while running away from the place by jumping from the wall.
Yes.
I also found A2 was going on the vehicle of the deceased Narsimha. That vehicle is MO2. That's what we said.
Jumping away from the wall. Also found A2 was going on the vehicle of the deceased Narsimha. A1 and A2, you notice this aspect was not spoken by PW1 and 2. You notice PW1 and 2 are the brothers. You notice may kindly see the evidence of PW1 and just few lines.
PW1.
One is the brother, 2 is also brother.
You want to read 1 or 2?
11, page 11, 1, first 11.
You notice at about 5 years back, when I was sleeping in my house, I heard shouts from the house of my brother. You notice the para.
Correct. Page 11, second paragraph, third line.
Then I woke up and went to the house of my brother. I found the dead body of my brother on the cot in the veranda. Then I made hue and cries. At that time, A1 was also present on the spot. At the relevant time, the parents of A1 also present in the house. They were sleeping in the house. In fact, the parents of A1 were not known about the death of my brother. On my shouts, PW8 Maluth Ramesh, Lachiram PW2, Badri PW5, and the neighbors came to the spot. When I observed the dead body, I found my brother died due to strangulation with G wire, and the wire was fixed around his throat and pressed it so that he died. Both A1 and A2 were having illegal contacts. What is
So that I suspected that they may be responsible for the death of my brother.
yes,
He is the chief examiner.
because they both have got some illegal contacts. He suspected both might have done, but A1 was the presence of A2 was not there. He suspected.
He is not eyewitness.
Not the not, there are no eyewitnesses to the incident. Lordship may kindly say. And PW2, your Lordship may kindly say PW2 also, your Lordship did not refer this.
Same paragraph number 2. Para 2, page 15. At about 4 years back, my brother
Yes.
A1 is having illegal contacts with A2. So that there was a dispute in between my brother and A2.
Due to
I
dispute,
found that there are marks around the throat of my deceased brother. In the hospital, I found a mirchi powder with eyes of the face. It appears one why was fixed around the throat and the press slit so that my brother died.
yes,
This is the evidence of PW.
PW1.
PW2.
PW2. As per PW1 and 2, your Lordship, there is no reference with regard to A1.
Presence
A2.
of A2.
A2 was, presence of A2 was not there. Only, your Lordship, the incident was taken place in the house of A1. Lordship, it is the duty cast upon PW1 to explain, your Lordship, what had happened. And the next aspect is PW8, your Lordship, he came after PW1 and 2 enter into the scene.
PW8.
Yes, your Lordship. Therefore, your Lordship, at least there, PW1 and 2 did not refer with regard to PW8. Lordship may kindly see. They have come later. By the time, your Lordship, the incident was over and nobody was there. And therefore, your Lordship, there is any amount of doubt that PW2's evidence has got any value in it. Your Lordship may kindly see the PW3 is the son. Your Lordship, he didn't support the case of the prosecution. He turned aside. He says, your Lordship, he didn't know anything about the case. Your Lordship, the PW2 was introduced to shoot the case, to implicate A2 in this case. That's only the evidence, your Lordship, is running away in the back side of the house.
That is by PW8.
PW8.
Not by PW.
Basing on the lone circumstance, your Lordship, my submission is, your Lordship, it is unsafe to base a conviction. And further, your Lordship, the recovery of GI wire. Wire in the, your Lordship may kindly see in the bike, in the bag. It is in the bag and it is in the bike. Bag is in the bike. That is the case, your Lordship. And the that PW13 is the contributions for the seizure of the GI wire. Your Lordship, as per the evidence, PW5, 8 and 13, your Lordship, all of them are close relatives. It is admitted by PW13 at page 41. Just because their man was put up as witness.
41, no, on suspicion, we searched the.
No. Above, your Lordship, just ninth line, your Lordship, from top. It is true I am relative of PW5 and 8. Lotus PW5 is the father of the deceased, and PW8 also your Lotus is a close relative, and PW13. Lotus PW13 and 12, PW13 and 8 are relative, close relation of PW5, that is the deceased. Therefore, your Lotus, all the Lotus remaining witnesses, PW3, 4, 3 is the son, 4 is the daughter, both have turned hostile. Lotus, they are the persons present at the time. They didn't support the case of the prosecution. The Lotus, others are your Lotus Mechanically PW6 and 7. And they have not supported the case of the prosecution. The remaining witness is PW8. It is unsafe to base a conviction is a close relative, and PW13 also is a close relative. Lotus, in such circumstances, Lotus, when the case is based on circumstantial evidence, sole circumstantial Lotus, the conviction cannot be.
A1 appeal is 538 of 22. Next matter.
Next matter, that is A1 appeal.
A1 appeal.
A1 appeal.
Yes, ma'am. That's all. That's all, Mr. Prabhu.
Yes, ma'am.
Your Worship, PW2 and PW3 and 4 are the eyewitnesses, but they turned hostile. Your Worship. And the next thing is that your
Son and daughter.
son and daughter,
Why-
they were
why
there
they-
at the scene of offense, but they turned hostile.
Why they have turned hostile?
Might be to support their mother.
Huh?
To support their mother, Ava. Second thing is that PW11 is a person who, the witness for the extrajudicial confession. He too turned hostile in this situation. And it is supported for the evidence of PW8 here. Because PW8 came to the scene of offense after PW1. But he went backside of the house, your lordship. That's why he witnessed A2 running from the scene of offense, your lordship. And the second thing is that, your lordship, the recovery of G wire from the vehicle, your lordship, which was in the possession of A2, because he has taken the vehicle from the deceased. That vehicle belongs to the deceased. That this is given that vehicle according to the evidence of PW1 and 2. That he has given the vehicle to the accused number 2 previously, few days before this offense, and that was in his possession, and from that the G by MO1 was recovered. In this, your lordship, according so that as the case is based on the circumstantial evidence, your lordship, only the evidence of PW1 which supports that he saw the A2 leaving the scene of offense by jumping from the wall.
Which is
Do you have paper book, Mr. Prabhu?
yes, paper.
Please come to page 29. Cross examination of PW8. Page 29, first line, first sentence.
Yes. It is true, the husband of
Page 29.
29.
Page 29 of the
Yes.
paper book.
PW5 is
Paper book, page 29. You have to read from the top, page 29, first line, first sentence. It is
29 cross examination.
cross examination of
Yes, 29 it's
PW8 and by A1 counsel.
A1 counts.
A1 counsel. Internal page 10, first sentence.
Yes, Lord. PW5 is my maternal aunt.
Cross examination of A1.
A1.
Cross examination by A1.
5 acres of land.
Because paper, you have paper book with you. The problem is this is in 538 and 530. Only a sentence name is the It is not A1 council posed a question to PW8. It is not true to suggest that my brain is commercial. Ain't my commercial brain? Why? PW8 cross examination by accused number 1 counsel. వదిలేండి చదివాం కదా.
Even as per the confession, that's For a moment, your lordship, PW 13 evidence, your lordship, with regard to the recovery.
Yes, Mr. Prabhu.
With regard to the recovery, your lordship, the confession of the both the accused was recorded at a time. What is the joint confession, and both of them were present, and
538 ఏం చేస్తారు ఏం చేస్తారు 538 వచ్చి 520 It's on 27 27 December. Yes. Item 23 Prabhakar Reddy.
my girlfriend wanted to verify the certificates filed by the petitioner. What is with
We are filing of
the
certificate.
wife filed an application,
Birth certificates.
birth certificates and Aadhaar cards. As per the case, your lot is the appellant is the
Date of incident as per prosecution.
as per the date of incident, your lot is
Mr. Papa birthday. 2
lot
seven,
of the
2005
report was given on 8/8/2015.
8815.
15. Lot is the victim's date of birth is lot is 1/1/1997.
Mr. Papa.
As on the date of giving report, your lot is 18. She crossed 18 years.
Mr. Papa. Confirm.
Lot is the then. Birth of the first child is your lot is on 17/1. May I give the date of birth of the children? Your lot is 27/11/2015 is the
Second.
first child,
First.
female child.
Second.
Second 17/1/22.
17
22. It is hospital records also have filed a lot.
So
In the said records, it is mentioned the
marriage. Tapiskuda marriage.
it is specifically mentioned the husband's name as petitioner.
What do you say about the first marriage?
First marriage, your lord, on the day I explained, your lord, is
Separate.
they separated and she married some other, and she is living with another man, and I got children also.
It's in the instructions.
This section.
Second paragraph.
Please read.
It is submitted that on an inquiry, it is disclosed that the convict prisoner got married with the victim and they are blessed with 2 children, aged about 3.5 years and 2 years respectively. That the whereabouts of the convict prisoner's first wife is not known as she is not residing in Gatkezar police station limits.
That's it. Please, Prabhakar Reddy. 25,200 rupees.
25,000 in an
ఈ పనులను మాత్రం చేయొచ్చు.
that is
మ్యారేజ్, సెకండ్ మ్యారేజ్, ఈమెకి ఇద్దరు పిల్లలు.
ఈ అసలు వైఫ్ ఇప్పుడు కట్టేది ఆమె ఇంట్లో పనిచేసుకుంటుందా వెరీ వెరీ పూర్.
వెరీ పూర్. ప్రాబ్లం అదే, ప్రభాకర్ రెడ్డి గారు అందరు క్లయింట్స్ వెరీ పూర్. ప్లంబింగ్ వర్క్స్, ప్లంబింగ్ వర్క్, టెక్నికల్ వర్క్.
He was doing now your lot is the wife has to furnish your lot is he is doing ఇంట్లో పని చేసుకుంటారు mates.
10,000. Yes. Wait for the object.
At the request of
You have already completed it. Yes, ma'am.
This case is based on circumstantial evidence, your lordship, and in this I read the evidence of PW 8 on page number PW 10 on page PW 6 on page number 22.
20.
22. According to the list of witnesses, your lordship, he is a witness, he is in the list of witnesses, he is a person to which extrajudicial confession was made, but in the evidence nothing is like that. Yes. I'm the resident of Gundam Japalli village at Narsimha. I was former Sarpanch and presently I am an agriculturist. I know the abuse. I know PW1 to PW5. I know the disease. There used to be disputes between the accused and the here your lordship, the whole story will be there. There used to be the dispute between the accused and the family of the deceased with regard to the employment of deceased father. The deceased father was working as village revenue assistant, that is Ramlu. We have conducted panchayats with this regard. The reason for the dispute was that Ruchi used to say that as he is a son of Ramlu, he alone is entitled to do village revenue assistance work and accused has no right over the same. As such, the panchayat was called. I was also member of the said panchayat. In the said panchayat, we resolved that the accused and the deceased family shall attend village revenue assistance works on a rotation basis. Rotation. The same was obliged by the accused and the deceased family. But some dispute arose as aid was not paid with amount by the deceased. As such, the panchayat was called for non-payment of money to aid. This panchayat was postponed and on the very next day, the death of the deceased occurred. Upon the receipt of the information of the death, I rushed to the spot and found deceased in pool of blood as he was axed over the head. I came to know through the villagers accused caused the death. I was examined by the police. Cross-examination. It is true there was a rumor that one Parkala Venkana might have caused the death. Witness adds that the cause of accused only caused the death. I was not the eyewitness to the incident. It is not true to suggest that accused are no manner connected to the alleged offense. During Panchayat, we have reduced our decision into writing and the said document is with the family of the deceased and the accused.
That was not collected.
Yes, your
By investigating.
that is not true. As this is based on the circumstantial evidence, your lordship, according to evidence of PW 16 also, the whole incidents rotates around the accused, your lordship. And there is a recovery also, and due to the death of the deceased, these people, accused number 1 and 2 are the persons who will get the needed job. So there was a motive behind this in this, your lordship, and as is a case of circumcision, motive was there, recovery of the axe is there, but according to the FSL report, there was a blood stains on the recovery. The clothes were recovered of A1 and A2 clothes were recovered from the instance of the accused, but that blood group is not detached, your lordship. DNA is not conducted for that. One thing is, I want to make a submission in this, your lordship. All the criminal cases, blood group is not detached because of one thing is that the blood group can be detached only the blood was in liquid position. When the blood gets dried up, the group cannot be decided. That's why the group cannot be decided in all the cases.
You have been telling Mr. Ramnaro to find out on this. Most of the cases.
Yes, sir. In all the cases, this will happen.
So it should be in the liquid form.
Liquid form, then only that group can be detached, your lordship. When,
Liquid form.
when it is dried up, so it cannot be detached. When the blood gets dried up, because this recovery will be after some few days, so blood gets dried up. Due to that, the blood group cannot be detached.
That's all? Yes, Mr. Any reply?
Not only, when my friend was saying recovery, that recovery witness also turned hostile.
Recovery and
Recovery also he turned hostile. But absolutely no legal evidence.
yeah, one of them. Okay, let's see, deep business of this. Western company. Even for 24 years.
Item number 25.
Case. Counselor? Huh? Other side council already completed his ordinance. Where is your council? In a moment. Very good. Still. Actually, good.
Item 26. Inside Chandra House.
Please, Your Honor.
You are representing Mr. Prithviraj?
Yes.
Why it was urgent, Mr.
Your Honor, on the last occasion, we have filed additional affidavit as per the directions of the Honorable Court, bringing to light the arrears already paid since the date of application. Affidavit is filed, madam. Sorry, madam, affidavit dated
Is the date of your affidavit and US ordinance?
October, sir, number.
What happened to mediation proceedings?
My lord, they are futile, my lord, except for exchanging unpleasantries, nothing substantial took place. Exchanging unpleasantries, nothing substantial took place.
Where is your affidavit? Is not there.
My lord, affidavit is there.
You serve copy on the other side.
Yes, served copy, my lord. Served copy.
What do you say?
Is completely substantial.
Substantial or baseless?
Because the whatever the issue here is,
You have extra copy, Chandra. Now, please, you can make your submission.
yes. So, sir, coming from us.
No, we have already had facts. We only, no, we have asked him. He
Yes, sir.
said,
Yes, sir.
we are not concerned with mediation proceedings now.
Right, sir. So, the thing is, they have come, section,
Wait.
in the report mediation.
That is paid now, anyway.
Right. So, in the petition, it's clearly mentioned that my client, which are coming from whereas the other way around. Then the gentleman has been in the maintenance from Jan 21 and also but and even before that, something has was given 2019.
Who is asking 50 lakhs? 5 crores. Wife is asking 50 crores. 5 crores.
Yes.
What is the offer given by you?
Sir, it's already paid 79 lakhs.
No, we are not asking you payment to be paid, etc. What is the offer?
So we are somewhere about 45 lakhs. We also the central government interest for the business market. And you all know it.
45.
45 lakhs. Suppose the property is 45 lakhs plus there is 170 lakhs.
With
And so lakhs. And then also lakhs plus the yojanas have been applied for the daughter in the town of SBI. 20.68 lakh from January 21st to this. So there is more mention here that the respondents is not maintaining.
Your Honor, I'm sorry, additional USR number
yes, sir, number.
for additional affidavit 105963 of 23.
FCOP is posted to which state now?
Again, it's today only.
Stage.
It's an plaintiff evidence stage, my lord.
What is the time given for vacation of this particular person?
My lord, in fact, the final order not yet ready, my lord, not signed yet, not been uploaded, so we don't know, my lord. Only operative portion is dismissed, Your Honor. But
Which one?
we filed the petition against the eviction, my lord, and the operative portion is dismissed, but the final order not ready yet.
They have granted you 2 months or 3 months time.
No, my lord, I am not aware, I said, my lord, because it's not ready yet.
So I have some question regarding the petition. So it was part and artwork family organization and respondent of the petition, the respondent. So we are clear was being maintained and given the maintenance. So we are clearly our evidences taking that the gate was not deserted and amount of
We are not deciding OP or we are not deciding appeal.
Yes, sir.
This appeal is against an interlocutory order.
Yes, sir.
Right?
This is the challenging the.
Please confine your arguments only to this particular.
Yes. So he's stating that she is not working, she is not only the respondent is not maintaining her. I am not because she is already as the property Meerut.
What is evidence? One second. Where is your counter in IA 1096 of 2022? Where is your counter to this interlocutory application?
Yes, sir.
186. Page 186. This is the counter filed by Mr. Sharma, Colonel Samir Sharma. Where did you mention that she is owning plot or flat in Meerut? You can't make submissions across the. You have to mention everything. Where is that in your counter?
May I respectfully make that submission?
Take an excuse, sir, but we gave one.
What's your name? What's your name? So you are now entering appearance on behalf of respondent.
Yes, sir.
So and so accepts notice on behalf of In the meanwhile, get that order.
I'm trying.
Meanwhile,
Obliging. In fact, my one humble submission regarding mediation, my lord. With all due respect regarding the amount they want to pay, my lord, the parties are at the impasse in the initial stage, my lord, regarding divorce. One wants divorce, one does not want, my lord. Hence, mediation also is futile, my lord. Whatever mediation dates are there, that is being futile, my lord.
self is still pending.
Yes, my lord, it's in respect to FIR filed in Uttarakhand to quashing of the FIR. It's completely different. Pending, my lord. Obliged.
This last vacation was the Kachigura just picked up from Bangalore and
Obviously, is not.
he's not interested. Maybe closely last.
And up 2 days.
No, 6 days. 29th, 6, 29, 6, picked up at Bangalore and they are alleging 6.
No representation. We have
Nice.
item 25.
Sorry, bro.
How much time it will take?
45 minutes, half an hour.
Then it will go to for 16th. Very 16th, Mr. Monday we have holiday. So Tuesday we have to hear bail applications. Wednesday is a dedicated filing. So we have to dedicate to this case only on Thursday. 16th. 16th Thursday.
Some difficult.
Difficult అంటే 14 పెట్టేసి. We will list it on 14.
Then 5th, 14th. I'm not very sure. Some small minor operation, I may have.
That's 15 better.
Post lunch and.
25 at request of Sri J. Prabhakan and Senior Counsel Diplomatic B. Venkata Padma, Land Council for responding. List on 14th in the same calendar.
Last time, I had placed the books.
Books are there, everything is, we have heard him, he has completed within 15 minutes.
No,
Or 20 minutes.
the thing is, I have handed over books.
Books are there, sir, we will hear you on 14th.
Some by mistake, my office copy seems to have gone there. I'll exchange. I'll exchange.
అవి మాకు చెప్పాల్సిన అక్కర్లే ఏం చేయాలో మీకు తెలుసు కదా విత్ యువర్ స్టాండింగ్ అండ్ ఎక్స్పీరియన్స్.
It's my duty to take court. I'm replacing court's record.
అందరు చేస్తే బాగుండు, ఎవరు చేయట్లేదు. మంచి మోషన్.
I'm obliged. 14th.
May to the lordships. My lord, the petition before lordship is
He's A7, right?
A7.
What are the offences?
My lord, offences, my lord, the lordship will find the FR at page 20.
Yes.
Page 20.
Mr. Vishnu, did you collect papers, Mr. Vishnu?
Yes, my lord. I received the papers, my lord. I'm already, my lord. Yes, I have instructions, my lord, from the
67-2 application.
Yes, my lord. This is what is that? No, rejected on the ground because he. No, it's like that. It's not fine. He was he turned approver, my lord. His confession statement was recorded. He turned approver, then filed an the accused. Yes. Then the court made an observation. Kindly, may I just invite my lords.
Justice Surendra.
No. You lordship, the order that was early bail application that was filed before the page 9.
Designated court.
Page 9. Yes, designated page 9. You lordship, kindly see. Yes, Lord. Paragraph 11. For the foregoing reasons, in the light of the above, it is obvious that approver in custody cannot be granted bail by the trial court, and section 439 is not attracted in the case of approver. Remedy open is the petition is under section 482. This is the.
So this is order is dated 26th October 2020.
I beg pardon. It's order 23 order. 26th October 20. Yes.
What is the urgency?
No. This. Actually,
this you have filed 482 application.
Bail application has been filed under 480 of the provision because he is an approver. Only 480 is the provision under which he can come before the court. After filing the
action was taken by
registry. But it's interesting, my lord. The Supreme Court judgment says any appeal under 21 comes to bear any matter. But here, that's a case where the Honorable Supreme Court was dealing with 439 application. Yes, the judgment I just had copy, I just blessing. What it says, my lord, my lord, that was the case where the accused bail application was dismissed. Here we are different. It's only for 2000.
Sudhanshu Ranjan.
Yes, 2014. No, not Sudhanshu, my lord. This is Pragya Singh Thakur versus National Investigating Agency, 2014 1 SCC. 2014 1 SCC 258.
Paragraph number?
Your Lordship will kindly go to last page, page 27.2, 269, last page of the judgment.
Paragraph
27 1 and 2. Firstly, an appeal from the order of the Special Court under the NIA Act refusing or granting bail shall lie to the bench of 2 judges of the High Court. That was a case, my lord, where an accused bail application. Here he turned approver. That is the reason.
What is the relief sought in criminal petition SR number 12945 of 2023?
He is seeking bail.
Seeking to enlarge the petitioner oblique A7.
Yes.
See the language used in your.
No, my lord. Of course.
Seeking to enlarge the
Yes.
petitioner oblique A7.
Yes.
On bail
Yes.
in SC number 3 of 20.
Yes.
So
Because-
actually you have to fight appeal.
No, my lord, it's not that. My lord, that is the reason, your lordship can see, I have one judgment which is directly on the point, because the facts are totally different in the Supreme Court judgment. Page 33, your lordship can see, I filed judgment of the, that one in fact is certain, if I not verified whether the judgment was carried in an appeal.
Jharkhand High Court.
Yes, Jharkhand High Court. That is, your lordship, page 33. Page 33, it starts the judgment.
Page 33 of your.
Yes, I filed it along with the. Page 33, page 38.
This is by a single judge.
Yes.
Even then.
No.
Then we will consider.
Consider 15. Your lordship kindly go to page.
Who is the petitioner in this?
That is where he was also that your lordship find it paragraph 4. 34 paragraph 4. In the present case, the petitioner paid for granting his release on bail as he has been tendered pardon from approval under section 306 CRPC in connection so and so.
So
therefore, I am applied the exactly identical fact.
He is also an approver.
Yes.
What did the
learned judge, your lordship, internal page 38 of the judgment, paragraph 15.
finding?
No, I'll just read the judgment. Taking the second point first, there is no question of holding whether section 304 subclass 4B is directory or mandatory, as there is no specific provision in the entire criminal CRPC which gives a right to the approver to apply for it. As mentioned above, 413 CRPC does not apply to an approver. It applies only to a person accused of an offense. An approver, when once granted pardon, no more remains an accused unless he violates the condition of the pardon subsequently tried for offense. Hence, an approver, his status is that of a witness and not that of an accused. That being so, section 413 CRPC would not apply, and consequently, the discussion on the point whether section 306 subclass 4B is directory or mandatory is merely an academic exercise, and that too in futility. So far as the provisions of section 413 CRPC. My complete.
Where is the finding?
Therefore, my humble submission is this, in fact, on the basis of this, since he was an approver, since the Lana single judge Jharkhand, while Millard all the various judgments of the Supreme Court, including a constitutional bench judgment, arrived at a conclusion that application of 482 before single judge is maintainable, and he granted bail because he was a Millard returner. I was identically placed. Therefore, I filed an application before the Leonard single judge.
So did you cite the judgment?
Yes, I did. I filed it along with the material papers. I cited the judgment also, but the Leonard judge has taken I was of the view that the
Sudhanshu Ranjan is Jharkhand High Court. Let us see the learned single judgment, judge order. Criminal petition SR number 122. Paragraph number 3 is reference to Jharkhand High Court.
Yes.
Where is the finding? Read paragraph.
And unfortunately, yesterday only I could not be furnished to me. Only yesterday that order was passed.
You don't have copy?
No, not. Because only last evening it was passed. I did not lay my hands on it.
Paragraph number 3 is Sudhanshu Ranjan.
Yes.
Then you have to read paragraph number 4. Supreme Court in state of AP versus MD Hussain, so and so.
That's what I have cited. That's what I have cited. That's what I placed.
Bail petition filed by so and so should be on the.
Yes, that's what I placed. No, that is why I'm trying to make a distinction. In fact, the NIA before the trial court may file their application counter also, they have expressed their, they are not opposed the bail as such. But the learned court, trial court was of the view that 482 power cannot be exercised by me. It is only the exclusive power of the High Court. Therefore, I cannot pass any order. That is the reason I'm before my lord, before the single judge. Since the learned single judge was of the view, the 2014 judgment says all applications, my lord, that is only appealable orders. Because in a bail in the routine course, in the trial court dismisses the bail, we come here again by way of bail, there cannot be an appeal against that order. Therefore, my lord, I'm again under 488 before this court to consider the aspect relating to the accused who is turned as an approved. Therefore, my lord, in fact, after filing the bail, his mother expired on Monday. He wanted that is agency also I expressed this morning also I reported to the court his mother expired on Monday. In lot he seeks at least interim bail. If your lordship consider this has to be heard again at length after maintainable. That is unfortunate. My lord is because against the bail order they cannot be an appeal. That is the answer.
Yes, Mr. Vishwanath, what is it?
Yes, my lord, we filed the counter, my lord, before the, my lord, the special court page number 29. My lord,
What do you say with regard to maintainability?
Maintainability, my lord, my lord,
Bail petition or 21 appeal? Appeal under 21.
My lord, in fact, my lord, the section.
Suppose if it is. No.
Yes, my lord. In fact, my lord, if matter comes under 482, my lord. Yes.
21 subclause.
Yes, my lord. My lord, as far as my lord, the bail applications are concerned, my lord, the legal position is very clear that under section 21, subsection 4 of NIA Act, my lord, it has to be before the, my lord, the division bench of this honorable court. Mohammed Hussain versus State of Andhra Pradesh.
Bail petition itself.
Yes, my lord, bail petition. My lord, any bail application, my lord, after the, my lord, the orders of the special court. So it is maintainable. My lord, only my respectful submission is if it is only under 482 has to go to single judge. But my lord, this is with reference to 21-4. The Honorable Supreme Court has already, my lord, clarified in our state, Mohammed Hussain versus State of Andhra Pradesh case, where, my lord, the learned single judge granted bail Justice Govindarajulu. My lord, it was set aside and said single judge has no power. So therefore, it has to be before your lordships only. My lord.
1 second. Read 21-4. 21 deals with appeals, not petitions.
No, my lord. Yes. 21, one request. Yes, my lord.
An appeal shall lie from any judgments and
Granting or refusing bail.
not being an interlocutory order of a special court to the High Court, both on facts. Read, Mr. Vishwanath.
Yes, my lord. Appeals. Notwithstanding anything contained in the code, an appeal shall lie from any judgment, sentence, or order, not being an interlocutory order of a special court to the High Court, both on fact and on law. Subsection 2. Every appeal under this section shall be heard by a bench of 2 judges of the High Court, shall as far as possible be disposed within a period of 3 months.
Don't go to 2, 3, 4. Please confine your arguments only to 21-1. This is an interlocutory order. Is it not? Bail application order.
Well, that is clarified in Mohammed Hussain versus Malod, in the curtain of the judgments, Malod, because any order, whether granting or refusing the bail, Malod,
you have to file 482 application or appeal under 21-4.
Malod, may I say one thing, Malod, because of this, Malod, the status of approval. Malod, the difficulties, Malod, the Honorable Supreme Court held that the trial court cannot grant any bail. Only if at all after the approval, Malod, under only 482 has to be entertained. But Malod, this is 482 with reference to Malod section 21, subsection 1 and 4. Because Malod, before your lordships only, Malod, it is maintainable. Mohammed Hussain versus State of AP. It's very clear.
Mr. Vishwanath, that is single or division. That is not the first question. First question is whether they have to file appeal under 21-4 or bail application. First tell us, criminal appeal or criminal petition?
my respect, my submission is the trial court, while dismissing the application of seeking bail for approval. So therefore, the court said it is not competent. Therefore, it has to be under 482 as per the judgments of the Supreme Court earlier. Now, my respectful submission is, if it is a routine bail application, it is under 21(1) and 4 before your lordships. But because the nature of the application is an approval, so that is the difficulty. So now my respectful submission is, because there is a special provision, particularly in these offences, UAP, NI Act, special court. So this is maintainable before your lordship only, 482,
482 petition before a division bench seeking bail is maintainable according to
482 with reference, section 21, subsection 1 and 4. Because in view of the judgment
if you refer 21(4), he has to file appeal. Don't club both together. We will decide the matter, but the whole problem is he wants interim bail. That is the problem. Otherwise, we will decide on merits with regard to maintainability of this 482 application. You can't say both. The 482 read with 21(4). 21 says appeals. Word used is appeal. 21(4) says bail, accept granting bail or refusing bail. That is the language used.
Yes, yes. For general, either refusal or granted comes before your lordship because of the status of approval. So that is, first time, this question is coming. So therefore, lordship,
not first time. I think you have gone through Jharkhand High Court judgment, single judge. Approver. Single judge said bail application is maintainable before a single judge. What do you say on this? Page 33 order.
Yes, that as per the judgment of the Honorable Jharkhand Court, it in fact has to go to before the single judge. But if it is applied, Mohammed Hussain case, that is the difficulty.
What do you say on the death of the mother of the petitioner?
Yes, that is as per instructions, it is true that we got instructions.
Unless until we decide the maintenance.
Jurisdiction, I cannot ask for an order. In fact, on Tuesday also, I took a chance of moving a lunch motion also, the same issue, Lord.
Granting, considering urgency, we have granted lunch.
I'm so grateful. I'm so
important legal issue.
Yes, sir.
Grant you interim bail. Tuesday. If you want to argue on merits, we will hear you on Tuesday. But no interim bail today. Unless until we decide the maintenance.
Lordship correct on Wednesday.
Wednesday.
Tuesday.
Tuesday, sir. Please get ready and come back. Don't club 482 jurisdiction and 21(4) jurisdiction. Be clear. Whether
Yes.
appeal is maintainable or criminal petition under 482 is maintainable.
Yes, I'll verify, I'll examine. On my request, my respectful submission is, with regard to the legal position, to hear the both sides.
Heard.
Yes, I am not
Sugar, land council. Yes.
Item 32, my lord, it is against rejection of guardian OP. Lord, now parties have come to an understanding. Lord, actually it has to be listed yesterday and they have come on.
What is the understanding?
For settlement, my lord, they
The settlement we are asking.
settlement, my lord, custody of the minor children. They are the grandparents, wife committed suicide. So, my lord,
Grandparents agreed that the minor children should be with the father.
because they have already,
Where is the application? MOU, etc. You have to file some understanding.
memo I filed, my lord.
No. MOU.
Yes.
MOU a file.
Yes.
Student MOU. Where is Mr. Venkatesh Gupta? He is not there.
Actually, it was listed yesterday, some date last week. Yesterday they have come, but as the matter was not listed.
This is filed by counsel for petitioner. Parties have to file application, is it not?
Joint memo was not filed.
Joint memo they have to file. File joint memo, we'll hear it on Tuesday and decide.
Council, my lord, has also, my lord, informed them. If your lordship, my lord, some indulgence, my lord, to lord, both the parties to be present. It can be resolved.
FCA. Gopal Reddy appellant is the father.
Yes.
Gopal Reddy.
His father-in-law.
Gopal Reddy is father-in-law.
Yes.
Where is Mr. Gupta? Why don't you file MOU? File MOU, we'll decide.
Some date to last month.
Tuesday
Yes.
or 16th, Thursday.
Tuesday.
Tuesday, 14th. At request of GB Sivali to file MOU list on Tuesday. 59. We inform, you are representing? FCA idi. If a petitioner and an appellant, you are representing Venu Raman. What about Dhananjay? Did you inform him? Without informing, can you take adjournment? Is it proper? You have to inform him, Mr.
Sign function, my lord. Item numbers 43 and 44, my lord. These are the death penalty cases, my lord. The lower court record has not been.
What about the appointment of mitigator?
My lords, we are not insisting on the appointment.
So much we have problem. Today we are deciding, where is he? Mr. Mahadevan is here. He is going to argue. Let it be there in the list. In 2 matters, we have already appointed mitigators.
My lords, without the lower court record, we would not be able to.
Lower court, who are not hearing the appeals.
Yes, ma'am.
We will decide with regard to appointment of mitigator
Very
in
well.
terms of Manoj judgment. He is going to argue today. There are 19 judgments passed by Supreme Court. We will give you copies. And we have appointed 2 mitigators who are associated with Project 39 Capital.
Yes, ma'am.
Let it be there in the list.
Lordship, item number 28, Lordship. Kindly after 2 weeks, Lordship.
28.
8, Lord.
Why? He's
Lordship.
in jail or on bail?
Lordship,
You don't know. Let it be there. We'll see.
Item number 33 and 34, my lord.
30?
33 and 34. Lord, the urgency is that on the earlier occasion, my lordship had appointed that.
What do you want now?
Lord, may be taken up, my lord, either tomorrow or on Tuesday.
Tomorrow we will not.
Lord, the urgency is that. there are
Tuesday
two-
we will take up, but take your chance. We will hear only bail applications on that day.
Lord,
Or let it be there in the list.
Yes, the issue is that on the earlier occasion, lordship had appointed that to remit back the matter and asked me to file the council.
We will remit it on Tuesday. What is the urgency?
But because the connected petition that is there, it is coming up for evidence, my lord, in the lower court.
Tomorrow.
And tomorrow is the agenda.
You know what to do tomorrow. File memo saying that appeals are pending, listed on Tuesday. I can't teach all these things.
Expedition disposal order is already there from High Court, my lord, so my memos will not be entertained, my lord. That is the reason.
Anyway, we'll hear you on Tuesday.
Tuesday.
But Tuesday we are not sure. Wednesday is a dedicated final hearing day, madam, in our court.
Thursday, I'm out of station.
You are representing Ramya? Ask her to be here.
I am here.
You are Ramya. There is one more Ramya advocate. Therefore, we are under confusion. You want Thursday or?
Wednesday or Thursday.
But tomorrow, don't insist there. We will seek adjournment. Family court.
Actually traveling from
They are filing order 711 on this ground alone that the appeal is pending, so the petition is not.
Don't insist. You have to cooperate with him in getting adjournment. Items 32 and 33. List on 16th.
33 and 34.
33 and 34. 16th.
Obligation. Right, please, your lordship suggested one legal aid matter.
You have to go and submit your biodata there in legal aid.
Much of.
Right?
Much of.
whatever. Bombay, therefore let us give preference to Mr. Patan. Yes. You are a local. Yes, yes. Yes, Mr. Patan. Where is your client? Where is your client? He is in Hyderabad or Tihar? He is in Cherapalli. A6 is in Cherapalli.
Yes.
Yes, Mr. Patan.
My lord, I have already supplied the compilation.
I think your counsel on record. He has apprised you of the arguments of learned special PP NI, right? So now you are making your own reply submissions.
Excellent. That too, with short, specifically, precisely what my legal argued. Within 15 to 20 minutes, I will conclude.
Argued in respect of A6.
Yes. I will not touch. There is a boundary for me.
I will A2, A5, your friend is there to your left.
Definitely.
A3, A4, your friend is there.
I will not touch anybody. Only precisely to A6 only.
If you touch, you know what is going to happen.
That definitely. He's beside me.
Two people are there, left and right.
So far as दोनों copy notes. But what I argued, I have drafted it or compilation judgments का. वो जजमेंट अलग अलग एक कॉपी और ये बस उसके अंदर
How many judgments are citing?
whatever I have cited. So, and this is the precise only 4 pages rebuttal. Excuse me.
Main memo of written submissions on behalf of A6.
Yes.
Memo of rebuttal reply. Lyrics of authority.
Rebuttal is there. Very copy. Balance. A quick flashback, whatever I argued within 3 minutes. The first question is about the allegation against me. The allegations are very limited. Second thing, my lord, after registration of this crime, my name was not cropped up. In the first principal charge sheet, there is no reference of mine. In the first supplementary charge sheet, there is no reference of mine. Abruptly, after more than 2 years, my name was cropped up, and ultimately I was made an accused number 6. On the basis of the so-called recovery and discovery in 54/11 special cell diary. Next point of argument was 66/12 as well as 54/11.
Larger cost. So therefore, they cannot be second or third FIR.
Exactly.
In respect of the very same allegation.
So same.
Larger constitution.
Exactly. And that is clear-cut violation of Supreme Court's direction in Amit Bhai Shah versus CBI.
TT Anthony, right?
Exactly. TT Anthony, and more recently, Amit Bhai Shah.
Even my own judgment is.
Exactly, madam. I gone through that.
That
was the point.
Confirmed by Supreme Court.
Yes, exactly. The next point was the recovery as well as discoveries were made by a special cell Delhi. The special cell Delhi have absolutely no right to investigate and prosecute under UAPA without following Section 6 and Section 7 of NIA Act. And there is a specific judgment which is still in force. Bahadur versus State of Bihar, full bench judgment. Apart from that, all the matters investigated, registered and investigated by the special cell pertaining to UAPA was referred through my reference before the Delhi High Court, that is reference number 1/2012. That is yet to be decided. And what are the irregularities and irregularities? I have already produced that copy of the thing. The core issue, my lord, which I argued vehemently, was my entire connection with this case is based on the recovery and disclosure. That's the only issue. And as far as recovery is concerned, I already argued that it is in contravention with section 43D of UAPA, because it's a mandatory for the officer to deposit the person and the article seized from him with the nearest police station. That was not happened. Plus, my lord, there is an RTI application also that he was not arrested from the Saharanpur. The memos, etc., were prepared in the chamber of the special cell, Lodi Colony. Further, it is in contravention of section 100, 102, and 165 of CRPC. Next, my lord, my point was that whatever he discovered was well prior to the knowledge of the authorities, that is special cell as well as NIA. Because the entire data already demonstrated, the government of India, the machinery has written to the foreign companies, Google, etc., well prior to his discovery. So all the emails, etc., the objectionable things are well within the knowledge of the government or the prosecution agency. That is going to strike the very root of the soul of section 27. First thing is that.
1 second.
Yes, my lord.
1 second.
Well within the knowledge of the prosecution. Second, my lord, there are two disclosures. One is before special cell, that is related to 54/11, and subsequently here in this present matter. So, my lord, if we compare both of them, it is one and the same. And again, there is brutal killing of the soul of 27, because that already fact was known to the special cell. Further, it is known to this agency itself. There cannot be two disclosures for a single thing. Now, here in this matter, there are three disclosures. First leg is there is no disclosure because they're well within the knowledge of the machinery. Secondly, within the knowledge of special cell. Thirdly, within the knowledge of the NIA in the present matter.
So therefore, no disclosure.
Next point I argue, whatever material allegedly extracted from the laptop or electronic devices was ICR. And now while next thing is the issue that the Delhi special cell called them to assist them. Now, my lord, if we go through the entire record, the entire base of the conviction is that report given by ICR. And for that purpose, I have given the notification 13th October 2019, I think. On that day itself, the ICRT got the recognition to analyze the data. Prior to that, they have absolutely no authority. And
they can't even assist.
No, not. And further, my lord, that particular thing was missed. My learned friend who is absent is coming.
He will, otherwise, he will watch our proceedings.
Okay. It's above, the investigation officer of 5411 has given 65P, who have nothing to do. He is not an expert. And that particular event,
he is not an expert and is not competent.
Exactly.
Even according to Mr. Mahadev.
Yes. And thirdly, it is not established that all the machineries were exclusively within his control. That is one of the basic of 65B. That I argued. Next point, we argued on the issue of evidence of expert. There is a Regency International and Shamsi Alam State of Bihar, that two statements. Third point was photocopies. Sixth point was sanction. All these points were already argued. And what I am expecting from my learned friend to counter specific role of A6. I am restricting myself to A6 only. Now I will take my lord's attention on the rebuttal. Only 4 pages were there. My lords. In his entire argument, my learned friend covered 21 points. I have given the list. And in the second matter, it submitted the learned SPP specifically submitted touched in respect of A6 only on 3 points. Charge sheet, criminal conspiracy, and electronic evidence. Now, my lord, I will pause for a moment here. We are dealing with the confirmation and an appeal. The role of charge sheet came to be finished after trial. Even for reference also, my learned friend could not touch them. He can rely on the evidence, he can rely on the judgment. But now he is relying on charge sheet itself. But in good faith, I am taking it, okay, even as per his charge sheet, though there is technical part, we will forget. Even as per the charge sheet, my role was exaggerated. What I have heard and my learned friend has given me, there are specific allegations against me that there are only two important things which I would like to highlight. One is that A6 provided explosive substances to the accused in German bakery blast. And for that purpose, eventually, interestingly, I was the counsel there in appeal. So I was well aware of each and every aspect of that matter. Till today, A6 was never made an accused.
Till today in German
bakery blast Pune. Neither he was shown absconded, nor he was shown wanted. I have brought a judgment copy of the sessions court itself. Excuse me, better. Ian. There is no reference in the judgment, either absconding or wanted. Eventually, that only accused person, Mr. Mirza Himayat Beg, was sentenced life imprisonment with penalty, and Honorable High Court, Bombay High Court, has acquitted. He was no Himayat Beg, the only accused person, has been acquitted by the Honorable High Court. And interestingly, in this particular matter, there is absolutely no whisper about that matter. Simply, it's an allegation in that charge sheet that he provided the explosives to the accused persons, but no material, either direct, indirect, or circumstantial, nothing, no sort of evidence was ever brought by the prosecution in this particular matter to that effect. Second thing, my lord, about Varanasi. About Varanasi matter, I have been a report of 169 has been filed by the prosecution. So my learned friend trying to make the situation now, he is a sole the person that he was involved there, he is involved there without evidence. But for the safer side, I am explaining that both things in German bakery block, he was not named, and in Varanasi case, a report under section 169 was being filed. And I already produced a copy of that 169 report in my first compilation, page number 225 and 214. My lord, the winds and waves are always helpful for the abolition litigator. During the pendency of this period, I got a clinching flow relating to that case.
Which case? Varanasi.
Relating to our case.
This case.
That is 54 Abhik 11 on whose discovery and recovery in the entire case against me was 10. During that period, I think it is on 311. In this, the Malkhana, excuse me. Marking term. There's only 2 lines, my lord. I marked it. He is the witness in 5411.
PW 56.
PW 56. To whom the recovered seized article were deposited. In 5411. The trial is going on and his deposition was on 3rd of November in this month itself. He categorically stated that Mr. Manishi Chandra, the IO of the 5411 who deposed here 141, PW 140.
41 or 140?
140. 140. 140. That's two line. On 6/9/2014, the ACP Manishi Chandra deposited in the Malkala in unsealed condition. So the material on which I was put for gallows, that is the condition. Since the day one, I am telling that the NIA has chosen a wrong partner. That is special cell. And further, the recovery was not proved. The trial is not completed yet. No other witnesses have been called upon to prove the recovery or other things. Only on the basis of the testimony of the IO, the entire documents were not exhibited. I also argued on that point that mere exhibition is not suffice the purpose. The document required to be proved on its own strength rather than exhibiting it. These are the 2 things in charge sheet which my learned friend has got. Second thing, my lord, regarding criminal conspiracy, my learned friend argued, and there is, I can say there is a harsh word, misleaded this court rather. Actually, and as a matter of fact and record, misleading is not a harsh word. For we are working on such a level that even this word should not be used. Misleading, because it is going to hurt someone's feeling. So I'm not got other alternatives. He told that while arguing in a flow, maybe advertently or inadvertently, that he gone through the so-called disclosure as a confession. As a matter of fact and record, A6 has never given us a confession. In India, A6 has never given confession in this. No confession at all. That only point compelled me to come here from Mumbai to Hyderabad. Furthermore, the so-called persons, the confessions.
That one sentence made by learned special meet. Yes. So made you to come to Hyderabad. Whether he's coming.
He's coming.
We take him to Bombay.
Okay, he is welcome. So, neither he was given any confession. Whatever the portion my learned friend did before this honorable court was the so-called disclosure of 5411 as well as this one. That is the replica of that. I already discussed in length that first of all it is the knowledge of crime. Secondly, it is knowledge of special cell. Thirdly, it is knowledge of all the sanctity of section 27. The basic essence and ingredients were lost. Further, my lord, the huge emphasis was given by my learned friend on the confessions of the other co-accused. Assuming not admitting, there are truthful confessions. If there are truthful, relying on that, there is no reference and whisper regarding A6 in all other confessions of the co-accused. So that is going to be in the favor of A6. Further, my lord, in confessions itself and discovery itself, the judgment is self-contradictory. And welcome sir, indirectly the learned trial court has given me clean sheet. The emphasis of my learned is on para number 483 of the judgment. Only one line, my lord, I will from the judgment. Only one line, please. That picture will be clear. No, read, you can read. In order to attract section 27, the discovery must be some fact which the police had not previously learned from other sources. It is the verdict of learned trial court itself. And eventually, thanks to the learned sessions court, while he was dealing with the entire discoveries under 27, he has not referred to 6. Entire paragraph of discoveries, paragraph 483. So if there is any reliable, legitimate discovery, he would have discussed it. Absolutely. He discussed all other things. That is, more specifically, Exhibit P 326 and Exhibit P 451. That are the only two things on which I have been convicted, put to the gallows. But while analyzing the evidence, the only para 483 and my name was not there, neither recoveries was discussed. And ultimately, on last occasion, I was clarified that my fate was decided only within 5 paras. That is, issue number 30 and para number.
So, compilation.
Compilation can
5009.
Page number 5009, volume 11. That is the real demand. Only 5 paras. And whatever the statements there, copy paste was there, last line was given only. Para number 646 of judgment, 646 to 651. And in 561, there are only 4 lines. He has taken the photocopy, cut paste the testimonies, put it on these paras, and last line, therefore, in view of the above evidence, it establishes that accused number 6 created fake IDs used by the accused so-and-so for financial transaction and was in possession of the jihadi material and used to send the emails. Hence, accordingly, this point is answered in affirmative. If anything else, my learned friend can point it out. No issue. Now, my lord, next point was about photocopy. Admittedly, till today, all the exhibited documents were in the form of a photocopy, which my learned friend also raised that issue. I will not go in detail on that. But the learned trial court is expected to decide that issue if at the end of the trial, but nothing was done. That issue was unanswered till today. Next, my lord, electronic evidence. As far as electronic evidence, my lords are the masters of that. So it will not.
Learners every day.
My lord. But we are using my lord's judgments as a precedent. Only I would like to point out the things that particular ICRT, that particular extraordinary gazette, the authority and capability of the ICRT to conduct REO to assist them. And the question arises, why that particular IO has not referred that thing to CFSL or at least State Forensic Laboratory? Both are available. In Delhi, Delhi is the capital and everything is there. The CFSL of CBI is there, CFL of NIA is there, international things are there, but he chose to pick up a private person who has to do. If it is read in consonance with the recent statement of that particular witness which I have given, it was not in C condition. It is going to strike the very root of the recovery. That is the only submission. And as far as cognizance and continuations are concerned, we already discussed in the first session itself with how the cognizance is bad in law. If considered in totality, my lord, there is absolutely no material against A6 as far as this matter is concerned, and it is rightly considered by my learned friend. Even otherwise, anybody on his side would have done whatever only to take the attention of my lords from here to there. But if it is going strict legal sense, there are no cases made out. My humble prayer for his acquittal. That's all.
So according to you, A6 never made any disclosure statement. Is it so, Mr. Vishnu? Anyway, just think of, we will hear you, we will seek your opinion. Anything else, Mr. Bhatt?
No, man. That's if I let it make a submission, I will finish it right now.
One second. Yes.
That aspect of the clarity.
Next thing. What?
Because only thing is that if the case stands on the disclosure, then in strict sense of law, none of the disclosure was proved beyond reasonable doubt. If that breaks, nothing survives. That's all.
One more aspect. Anyway, we are hearing Mr. Mahadevan. Yes. There is one judgment of Supreme Court in Manoj versus State of Madhya Pradesh. Even before hearing the appeal or at the time of appeal, at any stage, we have to appoint a mitigator. So there are 19 judgments. Matter was referred to 7 judges bench on a different aspect for uniform policy on sentencing. So referring those 17 judge orders, we have appointed mitigators in 2 matters, not these 2, other 2 matters, where death penalties are imposed. So what do you say on appointment of mitigator right now?
No issue, man. Absolutely no issue. I have very big knowledge. Absolutely no issue.
Yes, Mr. Madhav. Mr. Vishnodhan, he came from Bombay only to make it declare. Only one sentence you have to clarify so that before we raise.
Yes. When otherwise also my that friend can be on limits. But I'll verify today. It's not 2 years now.
You are close చేసేద్దాం.
Yes.
You are asking for an appointment of mitigator or everything?
Whichever your lordship.
No,
Mitigator.
your convenience.
Finish the mitigator.
Please.
But,
Please give it to him. Anyway, he has no objection. You have seen, you have go through my order, right?
and here one of
Correct.
2020 That, my lord, for a minute, let us go back to the, you see, all issues started with Manoj Singh Jat.
Correct, Madhya Pradesh.
Kindly take the, my lord, para 217 of Manoj Singh.
Manoj Singh, complete document is not there. Anyway, paragraph number
Paragraph number 217.
217. 217, right?
Yeah.
We have.
Please to point out that this court in Anil versus State of Maharashtra.
One second. In our judgment, in our copy, paragraph number 217 starts reflective of changed circumstances and evolving discovery. According to no, it starts with.
It starts with it is pertinent to point out that this court in Anil versus.
One second, wait.
I don't know the Indian It is the last document is up to 26 paragraphs.
No.
Minus
Wait, 1 second. There are 264 paragraphs in our copy. This is judgment. No, we have SCC.
Many a times it starts with a para inverted commas. Nil versus State of Maharashtra. The exact direction was given in that.
One second.
At least the facts which the court deals with in given a case cannot be the condition for reaching such a conclusion. We therefore direct that the criminal court. It is our start. Last 8, 9 paragraphs.
No, last 8, 9.
Sentencing of the present accused.
Sentencing of present
accused.
One second.
Sentencing of
Correct. We got it now. It is pertinent to point out that this is 252 paragraph in our paper.
It's a different book.
In fact, this is filed by Mr. Vivek. Please read.
It is pertinent to point out that this court in Anil versus State of Maharashtra has in fact directed criminal court to call for additional materials. Now the entire distinct scheme of when this arises, mitigating when does it arise or not? It arises the moment the death penalty is awarded.
You are right. We are with you. But what to do? There is a judgment of Supreme Court. Not one. 17 orders. Even after referring the matter to 7 judges, Supreme Court passes 17 orders. Not one or two.
That's true. I will come to the merits and demerits of that.
In fact, we are with you, but we can't know this.
No, here, this direction, the direction given in case is not exactly what the other judgments are. They are not in conformance with this one.
Correct. You are right. So,
So I am telling, let us go exact direction it was.
Please.
Then only whether Either upheld or not upheld will be immaterial. Once we understand. Many a times by determining the sentence, the court takes for granted, looking into the facts of a particular case that the accused would be menace to the society and there is no possibility of reformation, rehabilitation, while it is the duty of the court to ascertain those factors. And the state is obliged to furnish materials for and against the possibility of reformation and rehabilitation of the accused. The entire thing is, these things are only towards one goal, that is, the criminal proceeding itself, there has to be some sort of rehabilitation and reformation for the criminals. So once the crime is proved, he is a criminal. Whether he will be menaced to the society if released or if he will converted to life or kept in jail, he may escape. These are the questions involved. And how strong it is willpower to do that. Because one person is death, he will be awaiting that. So that psychological circumstances that I'll be hanged, it will be there. So whether at that time the person regrets as to what he has done out, and in pursuance of that regression, then whether he thinks that I should live or not live, will they allow me to live or not live, at least live in the jail. See, these are the things which keep lingering in the minds of the death convict. So here, the facts which the courts deal with in a given case cannot be the foundation for reaching such a conclusion, such as already stated, calls for additional materials. We therefore direct that the criminal courts is not High Court. High Court is different. Criminal courts means it affects only the trial. As far as my interpretation is concerned, I've gone to the 3-4 times around. It's very clear, it's directed to the criminal, not the High Court hearing an appeal or pending an appeal. Criminal courts, while dealing with offences like Section 302 IPC after conviction, that to after conviction, may in appropriate cases call for a report to determine whether the accused could be reformed or rehabilitated. It depends upon the facts and circumstances of each case. Emphasis supplied. We hereby fully endorse and direct that this should be implemented uniformly throughout the country, as further elaborated above for conviction of offences. So this position, when it arises, my lord, that is once the death penalty is pronounced, punishment is pronounced, and sentence hearing, there will be different. This situation of mitigating circumstances comes between that.
No, call for report from where?
Jail.
No, he will not be in jail during trial. He will be on bail.
He is on bail. Once he is convicted, that's why I am telling.
See, your interpretation to the criminal courts is only trial court.
Yeah.
Right? Only trial. So then, in the very same paragraph, it is mentioned that in appropriate cases, call for a report to determine whether the accused could be reformed or rehabilitated, which depends upon the facts and circumstances of each case. So therefore, where from he has to call for the record? The criminal court.
Calling for records, my lord.
Report
From the jail. Because
during trial, he will not be in jail.
Not during trial. Once the court comes to the conclusion that he is found guilty.
Correct.
For sentence hearing next week.
No. Trial court found guilty that accused is.
Yeah, immediately will be taken into custody. No, immediately will be taken into custody.
Correct.
So there is no question of.
So by that time, where is he? Accused. He is on bail.
Not my lord. Conviction after pronouncing the judgment.
Correct.
If it is a judgment of conviction, I am finding.
So yeah, he will be taken into custody.
Person who is on bail standing on the dock will be taken into custody. That is it.
So from that date to the sentencing date.
Sentence hearing date.
So the jail authorities have to call for the record.
Yes. No.
Trial court. Trial court has to call for the record. Only for that short period.
Not short period. I'm telling that whether the period is short or long, differs on the time.
No. Mr. Madhavan, in some courts, forget about a matter like this. There is a box office or there is a double murder case, etc. Right? So what is that the trial courts are doing? Today they are pronouncing judgment, convicting the accused. Thereafter sentencing will be only after 1 or 2 days.
That is wrong in law. That's what I'm telling
So how much time it has to take?
Time.
Even on the same day they can hear on sentence?
No. Thing is, my lord.
We academically, we have not come to any conclusion.
No.
We are hearing you, Mr.
For capital.
Correct.
The court, if at all, when does the court come to a conclusion of death penalty, my lord? It is not on the judgment.
Correct. After hearing this.
Only first found guilty.
Correct.
Correct. Next date is given for sentence hearing.
When is the next date?
Maybe 1 day.
Correct.
Because it is a capital punishment. Both sides have to be given equal opportunity. That's what the government says.
Correct. On the sentencing.
Yes. On the sentencing. In Manoj's case, no time was given. And sentence hearing, there was no argument. And it was confirmed by the confirmed by the High Court. The Supreme Court said this is bad. And the second aspect is after sentencing, during sentencing, during what sentence have to be given, having the accused having the offense being proved against them. Now, what is the sentence? It is a thought process of the presiding officer of that trial court. Whether I should give death or I should give any life or whatever. Acquittal gone. That part of it is gone. Whether I should give life or death. At this juncture, the learned trial court judge has to think whether this is a rare case or not. First thing, rarest of the thing. Second thing, antecedents of that. How many murders he has committed like that?
Antecedents. Second.
Suppose this is the only offense he has committed. And suppose he is very young age. Maybe given sudden prohibition, he might have done something.
Correct.
Okay, he has to pay for that. At that time, the discretion is for the trial.
Correct.
Whether it's a fit case for death or
How the trial court has to use discretion. That discretion cannot be mechanically.
it can't be mechanical.
It can't be mechanically.
Generally,
It should be judicially.
it was mechanical.
Yeah.
Now the thing is, we have got all the science is so much developed. So if at all it comes in the mind of the judge that hardly 25 years, it has to be reformed. The court thinks that it may be or it can be reformed.
Tell us how the trial court has to exercise discretion judicially. What are the parameters which he has to consider? Correct, we have seen that. We are on the report now.
I am on the timing now. Not even, I am on the timing. And this ultimate time is next day when the sentence is going to be
heard.
That sentence is going to be ordered. These two are different things.
Correct.
Because I mean, minor demarcation is there. And many times what happens, next day for sentence hearing, and if it changes the sentence, this is what happens. That is bad in law. That conduct of the trial courts is bad in law.
What is good in law? According to you.
According to teacher.
What is good?
What is good is when the magistrate or when the sessions court has a discretion, either to life or to death, whether to brand it as a rarest of the rare or not. All these things are within discretionary. Nobody can touch it. There cannot be any guidelines to think like this, you act like this. It can't be. It differs from person to person, court to court. At that time, if at all it comes in the mind that is very young, maybe only one offense, he may be reformed. So let us give life punishment. Why does?
And it is not a rarest of the
not the or he is an old man. Accused is an old man of 75 years. Today or tomorrow he is going to die. Then why should I give the sentence? This question.
Which is inevitable.
So at that short period between thinking, thought process and delivery of the sentence or sentencing. This question is mitigated. So if we talk about feelings, that yes, I think I am having doubt. Okay, let me call for the background, educational background, then conduct of the case. Call for the and also healthy conditions, health condition of then jailer article have to give when the court calls for. And then Krishnaka afterwards they can say that next can say
But this, what is the time frame according to, what is the reasonable
no
time?
time,
Reasonable time we are asking.
no time frame is fixed. Fixed by
No reason. No, there is no time frame. According to Mr. R. Mahadev, what is the reasonable period between conviction and sentence?
That's what I. At the time of exercising that discussion on the day of sentencing the accused, just before that, opportunity to be given to both sides. In Manoj Singh case, that opportunity was not there for the defense. Even in our case, that there is no. He gave a letter, please don't give judgment, we know that you are going to correct. That is a complaint or whatever. In our case also, the Senate judge could have given a date, inform your advocate, ask him to be present on that day.
No, forget about your case. We will hear the facts little later. What do you say on the orders passed by Supreme Court with regard to appointment of litigator at any stage?
At any stage, actually, my lord, at any stage means it is after pronouncement of the judgment or before sentence.
Mr. Mahadevan, our difficulty today is, we came to know about these 19 orders passed by Supreme Court, even after reference of the matter to 7 judges bench. And we have agreed with those 17 orders, and we have appointed mitigators in 2 matters before even starting hearing the appeals. See, we have to take a uniform view. We can't take different views.
For that purpose, for taking a uniform view, the subsequent judgment which are it says it has to be referred to a law that's because this there will be a legal anarchy.
Even after reference, the judgment which have cited and filed copy, we have referred in our order also. Thereafter, Supreme Court has passed 19 orders. That is our difficulty.
I do understand the difficulty, but we have to think.
That is the view we are taking.
Before sentencing, when there is opportunity given both the sides argue, at that time advocate for that group. Argue something wrong only.
What we are saying is, we will hear it. Hearing, we don't know what is that we are going to do. We have not come to a conclusion. What we are saying is, we will appoint mitigators first. We will call for the report. You have seen the direction, 7 directions. We will keep it with us. Thereafter, we will see.
No, I am objecting for that. Because that aspect will directly affect the fundamental rights of the prisoner.
What to do? The Supreme Court did not consider that. The submission made.
No, my lord. No. What I am telling, even for High Court, this step can be taken when the court comes to the conclusion of.
Mr. Mahadevan, we are with you on that. There is no difficulty at all. Matter is not before us. Matter is before the Supreme Court. Even Supreme Court referring the matter to 7 judges bench. Supreme Court passed 17 orders appointing the mitigator. Therefore, we have agreed with the Supreme Court.
I'm coming to that.
Actually, we are with you. But as per the what to do? We have taken a view.
And our questions are nullified. That's all. 0. But I am telling you one problem are this. Mitigator. Somebody files a petition, he is appointing somebody as a mitigator.
We will not appoint somebody. We will appoint the persons who are attached with project 13 in capital.
What happening? That is where the things are going wrong.
What we do? Go to Supreme Court and get an order. Get a clarification.
That's why that is the reason. in the he said there has to be uniform code of conduct for that. Otherwise, it will lead to all confusion. Different courts may pass different orders. Then everybody will be in problem, accused as well as the prosecution and also the advocates of. And I am telling you, when we are at the stage of mitigating service, then definitely what, suppose I am a defense counsel, I will say, sir, he is the only son, sir. Sir, he is only 30 years old. This is the only offense he has committed. There are no other offenses. And he is a postgraduate. He has responsibility. Right to present these mitigating circumstances is the advocate who is representing the person in the court. Now, what happens if somebody files a petition and somebody is appointed? Police may pump all the police information into the jail. And did you really do that? Or somebody else did it? How it is done? They may, and suppose the accused refuses to answer to the mitigator, they may write a negative report that he is very arrogant, he is going to. Then where shall we go? Where does the court indicate? So these are the practical difficulties. And that too, there has to be a consent from the accused panel. Ultimately,
It is not the law laid down by Supreme Court. That is that we can do. Supreme Court said there is no need of consent. Supreme Court is not waiting for the larger bench judgment. Supreme Court is passing order after the order. 17 orders are with us.
might be. But the thing is,
No, we said clearly, we are with you. But Supreme Court orders are coming in out. We want to take it uniform. So therefore, make your submissions. We will pass orders. Mr. Mahadevan, we complete your arguments. We will take a decision on appointment of. We will pass a judicial order, whether this way or that way.
because I have seen the order.
Correct.
Your lordship has given some conditions and all. Now, what happens, my lord? The mitigator who is appointed, or maybe a PhD scholar, whatever, if he is hired by the police, another recording will be done, electronic records, these things are there even. Nowadays, we don't know who is recording what. And suppose in a case, I am just giving a small example. In a case of murder, suppose a father and son kill a person. The later on father says, I am 70 years old and a local bode kotha. He was not there to prove that. Son will be out. Father will be inside. If he is punished to capital punishment, then a petitioner goes, actually I did not do that, my son did it. He may say that. Then what happens to the case? He is already convicted. It is practical. We can't understand the case. Even see, I have been dealing with this case. Not only this case, many cases. We have one case now. I only did everywhere. Only this case, and this case also, whether conviction is not in my. My duty is to see that rule of law.
You are not bothered about the last page.
Claims are not permanent. Cash is also not permanent.
Nothing is permanent.
But still, we have the desires. That is the difference between all the nuns and the man. Problem is, here there is every chance.
Okay. So at this stage, appointment of litigator is impermissible according to you. We'll consult. We'll consult.
At this stage, at the stage of argument.
Correct.
After coming to the conclusion, on the day of the judgment, again, in capital punishment case, madam, once death sentence is awarded, again a reference letter has to go to from here. 3 months time has to be given, date has to be fixed. Meanwhile, if he prefers an appeal, like in HIGHCOURT, again, it has to be heard along with the referred. Then again there will be a referred.
One more mitigator.
But every time it cannot be.
Either way, this matter will go to Supreme Court. Either way.
Supreme Court judgment, sir.
No, either way, this matter will go to Supreme Court, Hastinapur.
Wait. Rather, I never thought, let me frank, I never thought when it was posted for judgment, I only thought at the most circumstantial evidence connecting A2 to A4 in the scene of offense, Hyderabad movement and all, they will be considered to drive because nothing direct evidence is there, and A5 and A6 will be accomplished.
So that was your anticipation.
That was my balanced anticipation. But the thing is, what happened? A5 actually A6, some recovery, some they are showing. A5 nothing is there a lot. But the entire case revolves around him because they are in Bhatta.
Anyway, so mitigator over, right? Your submissions are.
Yeah, mitigator brought.
You are opposing. It cannot be at this stage.
No, my suggestion is not. At this stage, in this case, especially in our case, it need not because let us wait until judgment is
right.
At that time, then they can go and because now it is still arguments are going on. Our entire defense will get shared. If police come to the inform because what happens now? There's a great point to wait to understand these aspects.
Don't say. Live streaming is there. Don't start those things.
These chances are
Go there and make this submission there. Not
the chances are
we are not supposed to.
chances are that even not only police cannot. Suppose that this is from this side somebody penetrates as a mitigator. Then imagine what may happen.
Supreme Court appointed mitigators who are associated with Project 39 Capital A.
Even within it, maybe somebody needs.
Correct. We can't say no.
Can't. So what I am telling is, I am trying to view the things. What would be the negative aspect?
Correct.
Positive aspect I am not touching.
You are not supposed.
Definitely may not.
We'll consult. Next. Mitigator over. Next.
This juncture may not.
So Mr. Chandrasekhar is concurring with you.
Yeah.
No. Mr. Patan said no problem. No problem.
I've already gone through the entire judgments, that's why.
Yes. Next reply. You said you are citing some judgments today. Already that's all. We have bundled.
Which are very important.
Correct. So the judgment cited before this court. At the end, spiral bind.
Only one judgment, big judgment.
Citation?
Citation is 2014 Manor.
2014?
SCC.
Volume Japan.
Volume 7.
7 SCC.
716 Manor.
716.
Arun by Suleiman by Admiri and others. This is exactly similar to this case.
Which paragraph is relevant? Written arguments filed.
Where I think 32 died.
Delhi Akshata.
32 people died and about 200 injured. 85 injured. And this judgment was laid on 78 judgments, different judgments. The two volumes are included. Volume 1, volume 2. You can take volume 2.
What volume 2? Page number?
716.
716. Volume 2. Pink color.
No, not this. In this, I am not, because it's a big judgment, I brought the book, my lord.
Separate book.
That is, we will be having the.
So,
SCC volume 7,
2014 7 SCC you have not filed.
No, that I have not into my. It's a big judgment, really.
Which paragraph you are reading? The picture.
Yeah.
List of books which are money. List. It's not going to be anybody. Yeah, enter the minimal the list. If you furnish list, they'll pick up and keep reading.
This is directly in the index, first page index it is there.
Aslam Parvez on the first. ఇది కాదండి. 2014 7 SCs తెప్పించాను ఇందులో లేదు. బుక్ తెప్పించాను మా దగ్గర ఉంటుంది ఇక్కడ లేదా లైబ్రరీ. విచ్ పారాగ్రాఫ్ ఇస్ మీరు వదిలేండి. విచ్ పారాగ్రాఫ్ ఇస్ రిలవెంట్?
In this case, my lord, first I will bring the case. It's a very big case, just like how. Similar fact. It is a blast case. All the 10 accused are.
There also case was on circumstance.
Yes, circumstantial evidence, 85, 35 dead, 83 dead and 85 included. And this judgment based on 78 severe. And in this case, even the investigation agency is deprecated.
Deputed?
They are taken serious view of the investigations done by the investigating officer.
Supreme Court.
Falsely doing, like we have the TI confession, there also it was the same thing. That's why I said NI always does the same thing throughout the country.
Not only NIA, state police, worst got it.
After this, converting machines are on everything copy and paste. The procedure and all, even charge it, para 16, 1, 62, then 17.
Advantage, disadvantage with the technology.
See, ultimately, my lord, this rule of law is not.
So what happened in trial court convicted them?
Huh?
Trial
Trial court convicted, then
imposed
High Court acquitted them.
Supreme Court.
Supreme Court acquitted them.
Which paragraphs are relevant?
And there are so many paragraphs, my lord.
అది చెప్పండి.
Because
అది ఇక మన దగ్గర
and this was the case under quota. And your lordship knows that all the transactions from TADA were copied into quota and from quota really. After that expert this, after this expert this. And this will also go after the election, I think so. Some new may come because the hand bills have come now. New bills have come. They are formulating a new law for the terrorism act.
So they may repeal this.
I got all the bills. Yeah, it is already it is waiting for the assent of the president.
సెంట్ గారు మీరు ఎందుకు ఇచ్చారు మీకు? వై కాపీస్ ఫర్ సర్క్యులేటెడ్?
Not copies. It is internet. Everything is open.
ఎందుకు ఇంటర్నెట్ లో పెట్టారు? వై ఇట్ వాస్ ప్లేస్డ్ ఇన్ ఇంటర్నెట్ టు గివ్ ఇన్పుట్స్.
80% of the existing laws are copied.
Mr. Patan, Mr. Vishnuvardhan Reddy, Mr. Mahadevan, everybody has to give inputs to the members of parliament. You can give inputs to us. We will send it to Supreme Court. మీరు చదివి మీ దగ్గర పెట్టుకుంటే కుదరదు. You have to give inputs. Once bills were passed, what is that you are going to do? You will file under 32 writ petition before the Supreme Court.
No.
Challenging, what is that you are going to do?
That will not be done.
Then what is that you are going to do? Once bills are.
But in the present circumstances, change its circumstances, and we have been following only the British laws. The government has come to this.
Do you have any objections on the amended criminal laws?
That amended criminal law is not.
Do you have any?
Religious sections are out.
So you have certain objections.
Because throughout the world, it's only a religious conflict. Your lordship is saying this Israel. What is that Israel? Jews and Muslims.
Yes, please. Ticket. ఏంటి సముద్ర ఆస్పెక్ట్ ఏంటి? అన్ని ఆస్పెక్ట్స్ ఇచ్చేసారు ఈరోజు. యూ హావ్ టు కంప్లీట్ టుడే ఆల్ ఆస్పెక్ట్స్. No, which aspect you have prepared today? To reply. First item. They will come.
So yesterday I said the main scene of offense. Let us directly go to the very execution last point, where the conspiracy ends, execution is. That is the scene of. And my friend has been harping upon the very contents mentioned, so many contents of charge sheet. What is charge sheet, my lord? It is a gist of what the IO does, my lord. It is not an evidence in itself. He has also admitted that para 1 to para 42 of the judgment is only charge sheet. Not if the IO says it, you can ignore. Police evidence is not evidence of police officials not so relevant unless until there is corroboration. But whatever the trial court found, 42 paragraphs, Usama 6, how would I write, my lord? Because EW 140 and 149 clearly said in 2007 and 8 itself, we are after Indian Mujahideen, we have photographs of. Then how can the IO in this case say that my investigation, how is the investigation, whether he was a member of the Indian Mujahideen? If he is a member, he can say I was also there, then I became a police. It's not like that. He says it was found in so and so. As if he is the IO. That is the trial court also, it was so horrible, but at the same time very pathetic, my lord. The IO first gave deposition 1 day, 2 days slowly. It was being dictated. I was keeping silent and none at 10 public person. Also, very cooperative. Even in their complaint, they thanked the PP also. They never alleged anything against PP. No. Generally, public prosecutors, they will be mouthpiece of the police. They will say police is right, police is right. That was not the situation at all. It was the situation with the transport, not the public prosecutor. And, my lord, first day, second day, then actually that IO, CIO, PW 157 has this stammering. Nothing. So, Tana delayed. Okaro and the Then third day, he came out with a chief affidavit. They typed in the department and they were about to file. Till the accused were not produced. The PP one was in his room along with the IOs and all. And we don't have any clear to stand up.
These things you have already argued, Mr.
I am not told. This
Stammering you want chapter already.
No. This why I am particularly pressing, my lord. When they brought the chief affidavit, the learned public prosecutor himself said, terrorist case, negotiable instruments act, chief affidavit.
Come to the point.
Then, no, why I am telling is, the trial court asked the defense, him and I have a problem together, we are all human beings. Let us admit this. Then I will say, I said, cross examination, I will type and print, let him sign. How can it be? No, Mr. Madhav, you have to cooperate. Sir, without cooperation, if you do this, I will go to the High Court tomorrow itself.
Mr. Mahadevan, leave it there. Procedural aspects are over. Please concentrate on the judgment. So what are the arguments? That to reply. During reply arguments, you can't. We gave you enough time. 33 days or 32 days.
No, my lord. I think this special.
This you have already pointed out, Mr. Mahadevan.
After the PP read the entire chief.
That is wrong according to you. We will consider.
Chief of the IO, I went on cross-examining. Correct. What? He has not mentioned the names of the witnesses.
Nothing to do. Your
statement is there. And my main submission is a charge sheet is only a report of investigation.
Correct.
It is not an evidence itself.
Correct.
So whatever mentioned in the judgment about the charge sheet, it has to be questioned.
Yes, we will consider this.
Then, my lord, this coming from the scene of offense. My friend argued that the video was there, how these people from Malampet cycle stand, they went on bicycles, wearing shaft and all this explanation he gave 40 minutes. Just after that, Mergu Ala's evidence, my lord, kindly see Mergu Ala's cross examination. He clearly what stated, my lord, he stated something different. Then 128, 129 PW, Shiva Electronic and JC Brothers. My friend said, most of the time my friend was telling absolutely no cross examination, ineffective for only suggestion.
We have corrected him. We have corrected him saying, despite lengthy cross-examination, defense counsel failed to elicit anything from the prosecution.
Yes.
That's how we have corrected it. Second day, right? First day you are right.
No, see whatever, just I will not, I was silent. I was here when I was here, I was silent. Even I was saying from there also, I was silent.
We have corrected him. We have corrected him. That you have observed, right? At least.
Now kindly take my note, only this Mergu Ala's case only is most important.
PW?
PW 59.
Volume number?
Volume 2.
Page number?
Page number 2.
Volume 2. PW. ఒక నక్కనే కూర్చోమని ఏవద్దని చెప్పు అక్కడ నుంచి 5 ఊరికే పిల్లలు పెళ్లి పిలిచి కూర్చోమని చెప్పండి ఇష్టం రోజుకొకరిని ఇది అయిపోయేవారు
Page 403.
403
Page 403.
Yes.
Volume 2.
You are reading chief or cross?
Cross. Chief, yes, how many times he said that chief is only 1.5 page, correct? So this, the main only evidence available as to the spot is this. Then according.
Only eyewitness according.
Okay. May I read the cross-examination on
1 second. Page number
3. Page number 3, sir.
Still 3?
403.
Oh, right. 404. It starts from 404. Cross-examination.
Yeah. It is cross-examination. No?
Cross-examination by 2, 4 and 6. Accused number 2, 4 and 6. On one occasion I have gone
and
to
3 and 5 Shekhar was there.
Correct.
On one occasion I have gone to NI office at Begumpet. I was never summoned by any magistrate to give evidence under 160. The thing is, in this case, most of the 164 statements recorded by magistrates here and Bangalore also, magistrates were not examined before the. So how do we know that whether voluntarily it was done or how?
164 statements, they will not be examined.
They need not be examined.
That was his submission. That is the law.
But my lord, yeah, my submission is, they said in their cross-examination, most of them, I never went to action office and I never gave statement. My statement was not recorded. Then how the summons were served directly on the witness to appear for 160? That is the question is what? Who will clarify that? The prosecution has to clarify. The High Court did not clarify that. I asked him, when I asked him, no, we should summon. How did you get that? So what I say, my argument like I said, cinematic style, first script is written, then okay, when the cooker this cooker fellow will start summon. Take that, issue summon. He will be shivering, why I am summoned. And similarly, Abdullah all these things, already they are given confession on 2/9 itself. After that, now I am reading. It is true that at the time the learned magistrate asked me, it is true during TI parade conducted on 28/6, identified another person instead of April. Wrong identification. First TI parade. And second TI parade.
Same para. It is true, I did not state what all I stated in my chief examination. Today, I did not state the same before. State it second TI parade. It is true on 5/6/2014 for the first time I went to NI office. I do not know the designation of the police who summoned me to NIA. I do not remember whether I stated in my 161 statement, 164 statement before the magistrate during PI parade. I got married in the year 2013 January. Working is pharmacy.
It is true that I did not state what all I stated in my chief examination today. I did not state the same before the learned magistrate at the second clear period. It is true on 5/6 for the first time I went. His examination, if your lordship permits, 161 statement. It was on some other day. Whereas he said on 5/6 then I did not to suggest that I do not know the designation of the police officer who summoned me to any office. I do not remember whether I stated in 161 statement and in 164 statement before the magistrate during the period that I got married. These are the omissions. That is not vital. And let's see, to on the other side of the road bus stop, and she used to call. So that I will be available at then Anand Tiffin Center. After that, 2 lines after that. This is only tells about the family member. What all I stated in my chief examination, I did not tell the same to anybody after TV9 interview until I went to the NA office on 5/6. 5/6/2014, 1.5 years. Then it is true by the time I reached the scene of offense after dropping my wife in the home, the entire scene was cordoned off by police up to Chaitanya. It is true that the police did not allow anyone, including myself, to go near the scene of offense. I have seen the news of the blast in the TV. I did not lodge any complaint either in Saranagar police station or Malapet, complaining that I saw a person parking cycle at A1 Mirchi Center even after seeing the blast news in various channels. He himself gave a statement. If he is prudent enough to give a statement to the press reporter, what stopped him to give a statement to the police and say that I saw one person? They could have caught him immediately. Who is that? He did not say anything. After he did all this. What all the statement I did not tell the police present at the scene of offense. He could have, so many officers are there. If somebody is coming for help, definitely police investigation, definitely. He has not done it. So how to believe this man whether he is telling true or not? It is not to suggest that the police Anwar bet me. Because after the evidence that fellow came out, the witness, he was telling Putin mare, aadmi mare. So I it is not good for not verified. So as I do not want to tell that, kindly see this. This is the Manasarachina Vakyam. I don't want to tell lies, so I don't want to implicate info, so I did not identify. And somebody unknown to me at the first time here, 28. It is not to suggest that I did not identify A4 on the first occasion. I was again taken into custody for 20 days. I was present to identify A4 and in fact my second TI parade conducted by second TI parade. There in the requisition, in the requisition, the IO did not mention that this man is already summoned for TI parade to identify the
Understand.
He suppressed it. And he thought that the learned magistrate thought that no, I think they are information. She conducted. And he could identify only A4, not A3. And furthermore, I did not give any complaint to the learned magistrate holding second TI parade on 9/7. This date is wrong. Second TI parade was not on 9/7. For 26/7 9/7 then was
26/7/2000.
That is why T437.
Yes.
30th.
Third or second?
In my chart,
No, it is even. No, we have noted. We have noted.
it is not true to that I never saw it for at any point. Only these are the suggestions I give, Lord. After that, down after 5 lines. On 5/6/2014, the Sarunagar police called me in the morning and requested me to accompany their constable to NA office. How can this happen, my lord? If Sarunagar police has got some information that this man was a victim, first they have to record the statement. They have to confirm it. Then they should say that the case is being handed over to NA, so come to NA. This is the procedure what requires, my lord. And it is true on that date I was not inquired or my statement was recorded by Sarunagar police. Then a suggestion. What ultimately this shows, my lord, this person was not at. The spot there is absolutely no evidence. And this cannot be connected to say that he was in some hotel eating idli and one waiter says he regularly comes for idli. What is it relevant? Whether the accused is an innocent person or a guilty person. These are the common things every one of us does. We eat something somewhere. All this can come along. And secondly, my learned friend argued that he was insisting that these people drawn cash in Bangalore. Where is the evidence to show that with that cash they have purchased explosives? That has to be there evidence. It is chain is cut. From where the explosives were purchased, there is absolutely no evidence. Because every time my friend goes on moving there, for they come to they have money, Western Union. That person, PW 72 himself is a hour operator. Then for hour operator, what matters? Who comes and drops how much money? But the purpose, our purpose is butter mainly. If that is so, they are established. And it is, and added to this color, the peculiar judgment of nowhere there are the points. When it comes to finding guilty, just before that, I have given an analysis of judgment of which para contains what. Learned Trial Court directly comes to the with the chief examination. PW 56 sold one, PW 57 sold. Both of them clearly told in the paper. These two. Next, my lord, after coming the chain, another chain is PW 56, 57. 56 turned hostile. He did not support the prosecution. Instead of A2 and A3 or some other person, he identified A2 and A5. The IOS examination in Ross clearly says A5 never came to Hyderabad. IOS examination is there. A5 never visited Hyderabad. I'll take your lordship to 56, 57, my lord. These are the crucial witnesses. Only
We are
2 minutes.
We are at 56, 389. He was declared hostile.
56. Kindly see, my lord.
Chief or cross? Cross examination by you or by special PPCB?
No, cross examination only 4 sentences he did. And he says partly hostile. There cannot be partly or fully hostile, my lord. If a person is declared hostile, it absolutely means that he is not supporting the prosecution case. But he said partly and partly declared hostile. At this stage, the learned special PP for permission to cross-examine the witness, as a decided partly.
We have seen.
Percent. And added to that, in the chief itself, I am telling, this man, what we can identify, page, internal page 134, that is second page of the deposition. The witness identified the cycle which is already marked in between, somewhere which is rolled away to A2 and another. I found that police were making inquiries at Jumeirah. As such, out of fear, I stopped going to Jumeirah for 5 to 7 months. Then one police officer, after about 7 months, came and served a summons. The question is, my lord, again, when he has not in the class, he says, I have never gone to NA office, NA police never recorded my statement. How did the summons were issued? Who has to
Will consult.
because these were stock witnesses of the local police station. So admittedly, I think my lord, presumably, most presumably, the NA police might have called somebody in the Jumeirah calls in Hussaini Alam police station. How many stock witnesses are there? You ask me to Bijawada. This is what happens, my lord, generally. Because the witness will not be having that seriousness in the investigation. And the IO always wants to express that I have done good in investigation. But in this pursuit, what happens is they do all this. And it is impossible. Even otherwise, another thing. I identify MO6 is this. Exhibit P46 is the proceeding of TSHC, identification of cycle. P46, my lord, your lordship says, most of these cycle sellers, they said 2 months back before the magistrate. Because in the cross examination, their sentence is there, I never gone to any, I was never, because my statement was never recorded. Then summons of search of TI correct first by the third Metropolitan Magistrate in Hyderabad. P46 only the identifier. What about the TI corrects? He did not identify. He did not say that he said, I have gone to identify. P46 is the proceedings of the identification of cycle conducted by Magistrate on 7/6/2014. Yeah. 1.5 years. After 1.5 years, he summoned to identify cycle. And apart from this, and he said, anybody will test. And my signature on TI parent on 28/6 is P47. But this man was summoned. Man was summoned on all the 3 occasions, my lord. PW56, the chart, TI parent chart I have given. PW56, my lord, was summoned twice, and the first occasion A2 was identified. On the second occasion, A4 was identified on 28/6. And he did not identify others. Already he is outside. His evidence is not of that worth. Now, kindly come to PW47, PW57, on page 180 it is there. 180. So PW57, first TI parent, he identified A2. Second TI parent, he did not identify A3 and A4. And again he was summoned for third TI parent to identify A2. This is horrible, man. Lot of suppression between the judicial officers from the NA did not inform the subsequent magistrate that previously TI correct was done. If that has been informed to PW 130, 139, the learned magistrate would not have already. These are the suppressions, these are the malicious actions of the NA in trying to prove the case. And my friend keeps on reading this same thing. And in fact, I have read the 35 days also. Why did I take 35 days? I wanted to make his job also easy.
Correct. You made his job easy. No, you made his job easy, in fact.
But he went on.
He will got for a special PP NIA. He can't keep quiet, right? He can't. He has to do his job. He has done his job. And now our job is a bit difficult now.
Yeah, the most important. Definitely, my lord, every one of us are shouldered with heavy responsibilities. Then, my lord, 65B, even PW 81, my friend has read the first paragraph of the chief examination, my lord.
81.
PW 81. This PW 81 clearly states from accepting
not for giving convincing report.
Correct. Page number 490. We'll read Mr. Ramad. Agency government to address cyber security incidents in our country as well as so and so. By assisting investigation of digital gadgets pertaining to cybercrime cases reported by law enforcement agencies such as NIA in that time.
And he was directed by the Director General to go there.
Correct.
Assisting is different, giving its opinion is different without an authority under section 79. And my director says section 70 of the Information Technology Act, it is also mentioned. It is mentioned in section 70 that HIGHCOURT is formed by the government to assist the investigation agencies as far as cyber aspects are concerned. It is not, they are not appointed electronic examiner of electronic documents. There is no appointment. And my friend, he has already submitted, and that due is October 19, 2019. That from 2000, because these things might have come up in cross-examination in many cases, that HIGHCOURT is not an expert or cannot give an expert. And even that due is not expert examination, it has to be an individual. It cannot be a company or a firm and all. From signed by manager, like that. Because CRPC section 293 clearly says, section 293 clearly says, director of forensic lab, not scientist. There may be so many scientists. This man is only a scientist. And for this, we have argued for 2 days, my lord, I have seen in the live streaming. 2 days he was concentrating on this only, 81. The first few sentences are sufficient enough to throw away the evidence as an expert. Added to the fact that 65 certificate you are not given. Because my lord, regarding TA parents are argued exhaustively, rather. And the main aspects, my lord, confession also, he has read the confession for 2 days, my lord. Exhibit P 259 to 261. Those confessions, first paragraph, it is written that it was recorded in the case of Delhi and not of Hyderabad. Maybe a magistrate of Sukat. So what? First, and section 10 and 30, what it says, only a proved confession is applicable against court. Not every confession metropolis. A proved confession. So this confession, even otherwise, without admitting it on the name, it has to be proved first where in Article 6 of then that certificate copy can be used here. Is the extent of relevant here? Not enter whereas objection may not enter 25, 26, 27 only leading to recovery or discovery of the thing. That is not the and in that confession, after that 17th they were produced they do first. On 17th, one DSP Kanakaraju says, I can say to Akiri, not Akiri, I CIO, Deputy Venkatesh. See, Chief, I and CIO went to Bangalore. Whereas in CIO statement, he says he was in Delhi. They wanted to arrest 8285 directly on the court premises. There was a memo, I read it also. There was a memo. Then the police who are holding the custody, they said you bring a production warrant from Hyderabad. Yeah, we can't hand over. We take them back to jail only. This thing happened, man. This also I asked in the cross-examination. He admitted that he was in 17th there. When he is there in 17th, how can he be in Mangalore 17th? Along with TSP Kanakaraj. PW?
157.
157 is Venkatad. Kanakaraj.
Field 147 or 3.
How can he be there at 2 places? All this shows the total fabrication of the case.
Step by step, step by step. 133. 133. Yes. In his statement, I went along with CIO to Mangalore on 17 nights. And my friend argues one thing, my lord, and I can go anywhere, do anything. It is not like that. In the NA website, the lordship opens, my lord, it will show that each state, the scheme of the act and the scheme of the NA notification is, each state they will have one office headed by one SP, and for every 2 states there will be one DH. And for 4 states, there will be one IG. And the DGs will be only there.
Office is different from police station.
No, I am coming. Because this question arises in every trial. Now there is a notification that NI is not a police station.
What is the date of notification?
It has come recently.
Recent, 2021.
Earlier, they say, why take open office, my lord? Because of section 6 of NI. Section 6 of NI says, every information received under 154 CRC by the police station, they have to register, and if they want to add the sections of USPA, scheduled offences, they shall, the IO shall send a report to the state government should send it to central government, then central government should report back. If the central government thinks it fit, that it is fit case to be prosecuted for scheduled offence, then there are 2 options under section 17. That is NA Sumoto from Delhi Ministry of Home Affairs. They can transfer any case to any one option. And the second option is, if the central government has against state government, then state government can transfer the NA case to the ordinary case to the NA. After adding, only then sections of law for scheduled offences can be added. And there is a judgment, my lord, in this. The STF people of Kolkata asked a lady, telling that she is an ex. They immediately, after 121, 122, 123, these state offences and arms. The pistol also is recovered. They produce before a magistrate. Then these people think that they will add sections under UPA. They file a memo before the magistrate. Before a magistrate. The concerned magistrate says, UPA, no. He sends the same file as it is to session judge for a clarification. The session judge immediately directs the chief judge, the Kolkata Section Court, immediately directs him to add the sections and also remand the case and also police custody petition dispose of until filing of charge sheet. This is the order. This order was challenged before the High Court. The High Court bench clearly says that the learned chief judge of Session Court is also designated as an NI court. He is holding both the posts. And scheduled offence comes under NI. It has to be transferred to NI. And NI court is there to try maybe offences. There cannot be some other investigation to do that. So they are scheduled offences. And this happened, and the High Court quashed the order of the chief judge, adding sections of UPA, and then not other sections.
Only
FIR is not, even FIR is not quashed.
Only UPA.
Only adding of UPA, that letter was quashed. And all the proceedings pursuant to that also. Again, that they have prepared an appeal, I am appealing in the Supreme Court. Even in Kolkata, in that case, there are so many that the recent judgment is there. I will give that. I am not interpreting. So clearly it is mentioned, and the law mentions it. Now, in our case, 2 police stations, then merging into one case, but not merging into one case at Rangareddy when this case was transferred to 5th NDJ. Earlier, first time it was SC number 2 and 3. Both. Because it was transferred From where? It was transferred by our Commissioner of Police. Later on only this NIK into this. Now what happens may not jurisdiction part of it may not be any judgment. But everywhere the word shall is in. The Lordship peruses the sections under 177 to 188 of the CRP. What to be done, not to be done, zero FIR, everything is mentioned a lot. In this case, nothing is considered. Nothing is considered. And even I challenge it because first they did so many illegalities of conducting TI parade to Rangareddy jurisdictional magistrate. To correct that, they transferred the entire thing to Rangareddy. This is bad in law. And for some reason they continue to the special court for a APA case. Yes. The thing is, my lord, at every stage, they went on correcting the things. That's why in the opening day of itself, I said it was like a script written first. Then according to the script, the entire thing went. Even Mangalore, what my friend so many times read the Mangalore forums and all, computer and all. First, one team comes from New Delhi. Not everything it was without the accused, without the. In Kanamkaraju case also, he clearly said accused did not accompany us to Mangalore. Because these people were produced in this case only on A2 on 19, A5 on 20. How can they show any seizure at their instance? Section 27 does. It is out. Those seizures are not at the because it was not at the instance of the accused, nor in the attention or in the possession of the accused. Then on 8/10, after taking police custody was granted from 19/9 to 8/10 for A2. And for A5 was 21/23/9 to 8/10. On 8/10, another two conditions. Take this A2 to Bangalore. Another IO comes to picture. And he says, according to me, we see these things in plastic, this wire and all. How can it be possible when the police has already visited? Maybe Delhi police or maybe other police. Entire NA is one as far as the case is concerned. And another aspect, my friend argues is NA can do anything. It's not like that, my lord. NA doesn't have only this CIO and the 138 in the SP, Sunil Emmanuel. These are not the only two IPS. Only the IPS, my lord. Only officials in NA. For every state, there are DGs, IGs, ranks are there, my lord. So how can they say they also have one, they also have one? I'm an IPO, they also have an IPO, they also. It can't be. It can't be like that. Because PW 140 and 149. Vikas Vaibhav and Manish Chandra. Clearly state that these exhibits, these MOs were recorded, were belong to this case, crime 54 and the crime 63. How can they be just like that here? Now he says mail on xerox copies may not be accepted. There is no 65B certificate. And he reads on the mail sent out for 2 days. I did not read. I said, my sentence was only, I did not go through much. I said, they thought xerox copies can only session stamp is there. Other things are not there. How can there be additional session that stamp itself? There cannot be additional session that has about, how can it is first, second, third, fourth, much of administration is there, my lord. System is there. We have a very good system. That system is not followed. Simply the stamp quotation says, I know these. And the work as far as A5 is concerned, he was stressing that on the after 1 day after the thing in the May Jabardast. That was the name. Now kindly understand, my lord, the people who are affected or the people who stay in the vicinity of Dikshuk Nagar, how many people would have told to how many people that it was Jabardast blast? How does it, how can we presume that he is a conspirator because he said Jabardast? And the IO statement, my lord, he read the entire sheet. I was stating right from birth of how can he tell, my lord?
He can't, we'll consider that.
And he can, even in the charge sheet, what charge sheet, so many pages he has mentioned, but he did not mention in the running pages which witness on which day examined, what is recovered, which is the exhibit recovered.
That we will consider, Mr. Mahadev. You have argued extensively on that.
No, why I am telling is because my friend,
Your friend will argue.
he has to be given an opportunity to argue.
Argue.
I have added to that, my lord, the NA jurisdiction. NA court jurisdiction that I have challenged. It was dismissed.
By way of filing writ petition, that was dismissed. You filed SLP, SLP was dismissed.
I gave, did you find that? I gave him yesterday. Yeah, he asked me, I gave him. But RP also. And this RP, important point to be noted, my lord. The trial court cannot be so blatant and so adamant. There is an information to the court that RP is pending. It is listed on 15th. 13th was the Monday. It is listed on 15th. On previous day was 6th December. He wanted to give judgment. No. I will give. And before that, 27/11 also it is a last 10 plus 10.
26, 11.
26. Then 6th December, bargaining. Then 13th December, parliament. What is the same date was selected? And he was in a hurry to do that. No, I don't just understand. These are the things which are expressly written in this thing.
Anyway, we are not in hurry.
No, I'm not. See, even I'm not blaming the trial court for that. But what is important is, when I already informed in advance, this is an RP file. For the past 2 months, it is being posted. Now it is in final hearing list on Tuesday. On 15th, it is posted, sir. And it wait for one week. He gave a judgment. I went there. And then I checked.
Since judgment delivered, this
No, it is the case which has come in the paper today. Yes.
dismiss.
Let me go for final. My relief becomes simple. So it was dismissed that way. Then on 19th, sentence hearing is very important as per the Manoj case.
Correct.
Manoj case clearly defines if the opportunity is not given at the time of sentence hearing for arguing on mitigating circumstances and as to the quantity or quantum of sentence, then it has to be converted to law. It is clearly there, it is converted out. That is the latest judgment, the most latest judgment on
Sentence.
7 years are over, even in that case. Here also 7 years over. In that case,
correct.
After the High Court confirmed it, it was 7 years.
So here,
No, not the date of.
High Court judgment on it.
7 years, no, 7 years. With lower court and
correct.
After lower court, then High Court appeal, and after 7 years it came to.
Correct.
Here also 7 years are left in this case. And they are also facing different cases somewhere. What outcome comes, it's a different issue, my lord. But here
we are not concerned with the outcome of other.
The main point is my argument is entirely based on rule of law.
We'll consider this.
Nobody shall be punished wrongly. Because our law is no innocent should be punished. No matter so many guilty may escape. So many guilty may escape. But except according to the procedure. This is what is important. And
all are important things.
now, but for 59, all witnesses are circumstantial to what? They are not circumstantial witnesses to the commission of crime. That is more important. Circumstantial witness, who is a circumstantial witness? He will speak exactly at the commission of offense or leading to commission of offense. That information or that statement should be leading to commission of offense. It's not 1 month back he was in Bangalore, 2 months back he was in Delhi. How does it count, my lord? And JC brothers, my lord, JC brothers and Shiva, my lord, he said on that day, 2 hours he argued only for the 2 witnesses. And my friend also depicted how they went inside hill, how they walked, from which side, all these things. Then when it comes to the evidence, he said absolutely cross-examination nil.
No, no, not me. We have to repeat again.
No.
His submission was, despite lengthy cross examination,
No.
could not elicit anything.
These 2 witnesses, these 2 witnesses, there is no cross-examination.
No, according to you, there was nothing incriminating against you, therefore you have not cross-examined.
No, not even that one. My friend said, these 2 witnesses, absolutely no cross-examination. That thing is there, this thing is there. But what did they say on so and so day? NIF, the ordinary police, Sarunagar police came to us and seized the video hard disk.
Thereafter, reconstruction of scene. Thereafter, reconstruction of scene.
No, I will come to that. This thing only they stated. These two things exhibits, my lord. The P41 seizure report, P41, PW 128 electronics. P41 is the seizure report of that disk, and MO 46 is the disk. And my lord, PW 129, P39 is the seizure report of the disk, and MO 45 is the hard disk. These are on page number 730, 736, my lord, and 738 of volume 2. Volume 3, sir. Volume 3.
Anyway, page number is important.
So what did they say? He came, better. Why should I talk about it? Cross-examination is not what we ask, what we should not ask for. That should be, one should know. And he said absolutely no cross-examination, so it is admitted. What is admitted? Even otherwise, under the Information Technology Act, Evidence Act, the mere feature of a hard disk, how does one say that how it was in use? The entire apparatus system has to be seized. This hard disk, this is the CPU, this is the monitor, this is the mechanism it was running, even the camera. Nothing was such thing was seized in this case. Only hard disk. Everywhere they go, they take away the hard disk. They don't even mention which hard disk is that. And all these witnesses did not that at least there ought to be one sentence that our video is facing outside and the scene of offense is visible. Such things, nothing they said. They simply came and added to this PW 122, I think 120, I think, report. He said that the initial status which hard disk were taken, nothing is visible. Everything was blurred. So they committed reconstruction theory. Reconstruction, there is no law. Nothing, absolutely, there is no law. As to whether the police can conduct a reconstruction of scene with that too. There can be a graphic representation. In American law and English law, they do graphic representation. Here, they forcibly take give him a cycle, give him a box, then run from here, walk from here, back or back. What is this? This is horrible as per the file. Everywhere they do the same thing. They spoil the case. Not only they spoil, there is a hidden agenda of morphing. Nowadays, morphing is అది సగం వచ్చింది ఇది సగం వచ్చింది అనుకోండి, 2 మార్క్ చేస్తే నో రిలీఫ్, నో ఛాన్స్ అట్ ఆల్ టు ఎస్కేప్. And this is the thing done very which is the law of reconstruction of offense, madam. And whether the accused in police custody can be taken and forced to walk from here to there, put a cap, then ask that Shiva electronics. And he says it was matching, the figure was, the height and all was matching, something he has to. It is, sir, did not tell such thing. He did not say it was matching and all. Height, how at a distance, height can't be matched. Height can be matched within short distance, 2 feet, 3 feet. The persons are away, they look alike, they look same height. And these aspects added to PW59, it clearly says they were carrying, that one fellow was there carrying a tiffin box. He did not say cooker. Anybody can understand what is the difference between a tiffin box and a cooker. This is exactly my friend Shekhar has already approved. I am just, because I am going to the spot, then all these circumstantial witnesses, most of them said in their cross-examination, the second sentence is, I was not examined by NA and NA police did not record my statement. Then how did they get the summons for 164? Because the modus operandi of the NA is, first, because they may turn hostile also. To make it possible that they will not turn hostile, they summons, bring it and they will say, you are told before a magistrate, you can't go back. We will be initiating a case against you.
Forgery.
This is what it happens, my lord. And under threat, everybody does it. Everything is done in the same fashion. Everything is done in the same fashion. Even that cooker steel pallets person he was arguing, almost half an hour he argued. See, how does he know? One sentence is added, because these male people have come and purchased cooker, I could identify. How does it? He identified wrongly in the court. His identification was also wrong. And he was also summoned twice to the, he was summoned twice to the
TIP.
Third, once TIP period is over, they are back. So again, asserting his facts, giving a requisition, then that magistrate being suppressing all these material aspects, magistrate sincerely conducted the TIP period again, in that again, and added to that mosque. So if PW 56 and 57, they don't talk, they talk of one TIP period only. They were in 3 TIP periods, both of them. That means in one TIP period only signature is marked. Other 2 TIP periods, somebody might have gone with the notes and telling that I am Kaja person. Most possible aspect. If you have gone 3 times to a TIP period, you will definitely say that I have gone, been summoned 3 times to TIP period and one he did not tell the chief and the PP did not touch it, neither the court touched it. But the court says the judgment, no, yes, what yes, so. P46 and 48. He only identified both of them one TIP. How can it? And in the court, PW 57 did not identify so. Whereas the second TIP, first TIP, he did not identify. These are the basic aspects of circumstantial evidence, my lord. This chain is broken so many at so many places it is a broken chain. Except the first they wrote the script, then accordingly they went on. Then they might have missed something, again they sent another third time. And this man says, whether Delhi police have come, I don't know. I have come.
Script was not properly written.
No, not only the script writer is somebody different and the producer is somebody different. He did not follow the script. maybe correct or wrong, he inserted his own mistake.
How many aspects you have covered today? How many aspects you have covered today? See, we told you this is the special bench.
Yeah, no, I am not taking that. I am only taking one thing, my lord. The notes I have prepared, Bhavana camp and all, at length. Though he says so many things, even in Shamirpet, in fact, my lord, what exactly has happened with the accused? Their 313 statements are there, which I filed in the court. In that, from day one when they arrested, till the day of judgment, I only took instructions. When you were arrested, how many days were, where were you? In Delhi, they say they were kept in defense colony. Defense colony, a guest house in the cellar, where the sounds also don't come. And they were never taken anywhere. In Hyderabad, they were in NA office, Begumpet, which has cellar. Cellar parking unte danni torture unte. Begumpet. It is shifted to Gachibowli, NA side. They said so many people used to come and see them. They were not taken to Bhavana camp or CRPF and all. And your lordship is well aware in CRPF, Bhavana camp also. The burden is on prosecution to prove that how they have entered. Identical, everyone wrote, not who are only immediate auditors. So these are the main aspects of confession, seizure, everything is gone. Circumstantial witness, there. In fact, the documents which I have given the Lord, this I have to, this judgment I have to give.
Which one?
This Adam by
2014, 7 SSC.
Yeah. This judgment I have to read already.
We will do one thing. We will give you one more day, finally, one afternoon. All of you have to finish.
Yes, I have to finish
Wednesday.
half an hour.
Wednesday. Yes, Mr.
Next Wednesday.
Not Wednesday. Mr. Patan, again he will come from Bombay. He will take you to Bombay. Yes, definitely. You have to answer. Otherwise, that is the danger you have. But the small issue alone I can clarify. You can clarify. He will answer virtual. Yes. You can log in from Bombay. Need not come. No. Of course, you are welcome. I will come. Now, shall I clarify? Right. If you have answered, clarify. We will hear them. See, only one sentence. According to him, there was no confession or disclosure statement by A6. What do you say? It is there on confession. Confession. Sorry. Where exhibit? This is volume number 9. No. So let me accept. No. You can take it out. Question. If he wants to answer Wednesday, you can log in and you can. There is only question, only one question with regard to A6. A6, whether it's a confession or not. Clarify from the box. Yes. That's good. I'll say. Yes. Online means